Mentioning what you have said. May I have my lord kindly leave to my lord mention two my lord execution applications, my lord. My lord, they were returnable in the first week of November, my lord. They are not. May I hand over a copy of the orders, my lord? Good.
Is there any interim order expiring?
My lord, there's no interim order, my lord. The warrant of arrest
Until
was
6th
issued.
of January.
Could it be, my lord? Here, my lord, warrant was already issued, my lord.
Okay.
Actually, it was made returnable on 6th, my lord. If your lordship kindly takes a look at the order, my lord. এই দুটো order, ওইটা একটা matter, এটা একটা।
My lord, I want to mention a matter. I am a senior citizen, cancer patient.
Warrant of arrest has been issued. এনে produce করা না। The authorities are supposed to produce the, my lord, judgment letters, my lord.
All right. Monthly list of January.
Well, both the matters, my lord. Both, there are two separate matters.
Yes. Entire execution proceeding with connected application.
But there's no other separate application, my lord. They're only
All
executions.
right. Execution.
Could it be, my lord, December, my lord, monthly list of December?
Monthly under the heading execution and chamber application. Chamber application, monthly list of January. Thank you, sir.
I'm grateful.
Next.
My lord, I want to mention a matter, CS-COM 645 of 2024. The matter is listed to supposed to yesterday, but it was not come in the list.
Why? What is the matter?
Matter is compensation of rupees near about 50 crore from State Bank of India. Matter is of 2016. I am appearing in person from
What is this matter? Suit, civil suit.
Civil suit. By order dated 29th October, Justice Krishna Rao make it returnable on 11th November, but it did not come in the list.
Suit. It's a hearing matter of suit.
Yes, my lord, the defendant did not file any written statement.
All right.
It is
you mentioned in the month of January. Next.
My lord, I am a senior citizen.
Very well, I will
as well
release
as cancer patient.
Sir, I understand. I appreciate the difficulty, but I have to take up slowly and serially. The matters are already.
No, okay, my lord, it will be kept in lot B. It will be kept in lot B.
All right.
Lordship,
Thank you, sir. Next.
kindly grant me leave to mention one appellate side matter, Lordship.
No. Why?
Lordship, this is very urgent matter, Lordship.
What is the urgency?
Lordship,
I don't have any appellate side determination. What urgency you have?
Lordship, on 3rd November.
Take the microphone.
Lordship, on 3rd November, your Lordship passed an order in a matter which was from the determination of Justice Vishwajit Bosu, Lordship. In the said matter, you directed the college, Lordship, to schedule and special supplemental examination for the petitioner, and after that examination the university was directed to publish the result within a week. The petitioner duly appeared in the examination, Lordship, and the chief
mention before the regular bench. Next. Regular bench. Next.
Grateful, Lordship.
Matter. Item number 1 to the bench. But I am for the defendant number 1 and 2.
May it please your lordship,
Why is
appearing on behalf of the, this has not been kept returnable for the learned commissioner, commissioner appointed for conducting examination in chief of the witnesses of the plaintiff.
Yesterday it was fixed. Matter was mentioned yesterday.
No, my lord. It was kept returnable. My lord, the examination process is still going through, my lord.
When the time is expiring?
No, my lord, it is
Today, my lord.
12th of November. That is
Today.
Yes.
So you want an extension of time?
Yes.
Ashun.
My lord, the order of appointment is February 8, 2023.
The matter has appeared. No, paragraph. Should go. Who is for the plaintiff?
My lord, I am appearing on behalf of the plaintiff,
Mr.
Mr. Rohit Banerjee.
Rohit Banerjee, learned advocate, appears for the plaintiff. যেখানে appears হবে সেখানে appearing করে দাও তোমরা সবাই। appearing কখন হয়? যখন সাবমিশনটা রেকর্ড করতে হয়, মিস্টার রোহিত ব্যানার্জি appearing for the plaintiff submits. আর যেখানে সিঙ্গল appearance সেখানে appears. ওই হলো। তুমি আমরা সব ইটস এ টিম। যদি অন্য কেউ করে তাকে শুধরে দাও। Banerjee, learned advocate, appears for the plaintiff. Mr.
My lord, Shankar Pal. I am
Huh?
Shankar Pal, my lord.
Shankar Pal,
I am the
learned
commissioner.
advocate, appears for
I am for the commissioner. I am the commissioner.
Is the learned commissioner who is present? Full stop.
Different number 1 and 2.
Mr.
Jeet Rai, my lord. Jeet Rai, my lord.
Jeet Rai, learned advocate, appears for defendant number 2.
1 and 2, my lord.
1 and 2. Paragraph. The parties jointly submit that today is the time when the tenure of the learned commissioner appointed by the court is expiring for holding commission. Parties further jointly submit that the examinations are yet to be completed. Examination of witness is yet to be completed. Accordingly, they jointly pray for an extension of time. Paragraph. In view of the above, time to complete witness action by holding the commission by the learned commissioner already appointed stands extended till February 16, 2026.
I'm deeply obliged.
Grateful, my lord.
After completion of the commission, paragraph, the learned commissioner shall file the necessary report.
Grateful, my lord.
Next.
My lord, I am appearing for the plaintiff in this matter, my lord. No, I am appearing for the plaintiff in this matter. It is appearing at my instance for extension of interim order. My lord, the interim order is valid till today. My lord, in this matter, the interim order was originally passed. My lord, I have prepared a list of dates.
Extension,
May I hand that over to my lord?
Last extension on
Yes, my lord. Last extension was on 16th of September 2025, my lord.
paragraph. Ashok.
My lord, here there is one more issue. After the last extension, I have been granted a decree under an application for judgment upon admission. So, my lord keeps it any date returnable. I just want a confirmation because the defendant is not appearing, and there was an order of security as well. my lord.
Mr.
Ratul Das.
Ratul Das.
Ratul Das, learned advocate, appears for the plaintiff virtually. Paragraph. None appears for the defendant. Paragraph. Mr. Das submits that the interim order last extended on September 16, 2025 is expiring today. Full stop. He further submits, meanwhile, a decree has already been passed in the suit in favor of the plaintiff. Paragraph. In view of the above, but you have taken out execution.
No, my lord. This is a part decree only to the extent of 30 lakhs. My initial frame.
Part decree has already been done. Huh? In view of the above, the interim order last extended on September 16, 2025 stands further extended till February 16, 2026. or until further order, whichever is earlier.
And my lord, there was a direction for deposit of the amount lying in Standard Chartered Bank with the registrar. My lord, no step has been taken in that regard. There was already an order of security passed on 30th of August 2024.
All right. We shall see on that day, next day.
Very well, my lord.
The
Much
matter
obliged.
shall appear, Likhun. Then what for the matter will appear?
My lord, the matter for confirmation of the interim order may be confirmed, and only the security may be kept with the registrar, because there was direction for both these things which are left outstanding.
Take out an application for the keeping the security with registrar.
My lord, by 30th August 2024, it has already been directed. Several letters were also issued, but the bank is not complying.
Take out an
I will
application.
do that.
Mention
I
it.
will.
I will place it as chamber.
Much obliged, my lord. I will do that. Much
Sure.
obliged.
Next. Yes.
I'm appearing for the plaintiff petitioner. This is appearing at our instance. The interim order, which was passed originally on 28th August 2024, is due to
Extension of interim.
extension of interim order.
Last
It was
extended.
last extended on 25th September 2025.
Here for
I am for respondent numbers 1 to 4.
Should kindly also
Mr. Vasu Sastri, learned advocate, appears for the plaintiff. Paragraph. Mr.
Bhavesh Garodia. I will write my name and give.
Such and such, led by Mr. Subhashish Sengupta, learned advocate, appears for defendant number
Number 1 to 4, Your Lordship.
1224.
1.
Full stop. Since the interim order is expiring, where?
today.
Where?
Lordship, order of 25th September 2025.
25th.
25th September. The interim order is till 12th of November.
Since the interim order reimposed on September 25, 2025, expires today, comma, the interim order reimposed on September 25, 2025 stands extended till February 16, 2026 or until further order, whichever is earlier.
Lordship, in the meantime, the hearing of the applications.
Take. Microphone.
Lordship, in the meantime, the hearing of the application for further interim protection as well as their temporary application will be fixed for hearing. These are also pending.
The affidavits exchange.
Affidavit is exchanged.
We have filed a counterclaim. In that particular counterclaim, we have also, Your Lordship, filed an application for interlocutory relief, Your Lordship.
Lordship, there,
Counterclaim in the written statement.
Yes, Your Lordship,
So
written.
you have to prove that.
But along with that particular counterclaim, we have filed, Your Lordship, application, Your Lordship, for injunction. We filed a written
Lordship.
statement. We have a counterclaim.
Yes. Counterclaim should be treated as a plaint.
Yes.
So you have filed an injunction. That is permitted. I am not on that. But affidavits exchange.
affidavit is exchanged.
You have taken out an order 7 rule 11.
That has been dismissed, Your Lordship.
And there is an appeal
We have
pending.
taken, Your Lordship, that the suit is
Appeal
not yet
pending from order 7 rule
Appeal
11.
pending from the order directing them to furnish security. Since
May I take it, Your Lordship?
All right. So let the appeal be disposed of first.
That is fixed tomorrow, today only, Your Lordship.
Yeah, then go ahead and get it disposed of. Sure. Next.
My lord.
I'm for the respondent. Lordship, on the last
I'm for the
occasion, Lordship,
petitioner.
it was released by my Lord Justice
Ashwin.
Gaurang. And Lordship, this is a section 9. I don't think
My
there is
section
any
9
urgency in
application.
this matter. Lordship, we were praying for. I'm being led by
Here for
for the respondent.
Mr. Dutt,
I'm for the respondent.
respondent.
I'm for the
The
petition.
matter stands released on my personal ground from my list. Full stop. Paragraph. The records are directed to be placed before the Secretariat to the Honorable the Chief Justice for taking steps for assignment. আজকে এক্ষুনি পাঠিয়ে দিন সেকশন 9 কার কি আর্জেন্সি আছে জানি না
proper suit pending. The subject matter of the property has already been sold to a third party and the suit is pending.
all right আজকে পাঠিয়ে দিও তো কি হবে আমার ঘরে রেখে বোঝা বাড়িয়ে। নেক্সট।
Not one word because he'll not miss his.
I'm grateful.
Grateful, yes. Also there.
Item number 5.
I appear for the plaintiff, my lord. I was to address your lordship on
Yes,
Cox and
complete.
Kings. If your lordship could kindly, my lord, give me this indulgence, my lord. I'm ready, my lord. I want to do this.
Sir,
matter.
if I give you the indulgence, then it will go sometime in February. Choice is yours.
If your lordship could pass it over for some time,
No.
my lord,
Either you have to do it or you don't do it. I don't mind.
I'll do it. I'll do it.
Yesterday I spent 1 hour, more than 1 hour on this
Yes,
matter.
yes.
So no indulgence.
I don't have much to say, my lord, on Cox and Kings, my lord. May I only briefly say that the judgment deals with 3 aspects. First is
One second, slowly. And only one judgment has been cited.
yes,
So no question of giving any indulgence. এই বাহাদুরকে একটু ডাকো তো পাখাটাকে। হ্যাঁ
my lord, IA4.
পারো। এদিকে আমার দিকে। Yes.
But 3 aspects have been dealt with by
সৌরজিৎ
Dashgupta.
Yes.
3 aspects and 3
Take
objects.
the microphone,
Yes,
set it properly and
my
answer.
lord. But may I? There are 3 objects of this judgment. First is commonality of subject matters of the arbitration agreement. If it is a section 8, then the subject matter of the suit and the arbitration agreement must be common. And the relationship between the person who's applying for reference and the non-signatory should also be common to the signatory to the agreement. Now, my lord, first is commonality of the subject matter and the parties. Second is consent. Now, consent, it has been held that may not be express, can also be
Consent for what?
consent for arbitration by the non-signatory, may not be express. It can also be culled out from the conduct of the parties, performance and termination of the agreement. Now, if the non-signatory had anything to do with the performance of the contract or termination, then consent to arbitrate can be culled out from those acts. And the third is to prevent multifarious litigation. A party who is seeking to add a non-signatory to an arbitral proceedings would first have to establish that if that non-signatory is not added, then it will amount to multiple litigations, and that party would have to initiate various other litigations to establish his right. Now, none of the 3 aspects of this judgment is present in our case. First, my lord, on the commonality of subject matter. My lord,
So one is commonality of subject matter.
yes.
Second is
Consent.
consent for
Consent to arbitrate by the non-signatory.
yes. Third
is to prevent multifarious litigation, because the multiple litigation, because the party applying for reference would have to satisfy the test that the transaction that he is alleging is was a composite transaction. Non-signatory was an integral part of the execution of the subject matter, execution of the contract, performance and termination. Now, before going into this aspect, may I only point out, which I had also pointed out yesterday, that my right, the plaintiff's right, to recover the money due and payable from the defendant is not coming from the distributor agreement. The non-signatory, which is the holding company, would not have any right against the defendant to recover any money.
Yes.
And on the other hand, the defendant who is seeking to add the non-signatory, the defendant would also have no relief against the non-signatory. And to establish whatever, because there is
Non-signatory means the
holding company,
holding company.
plaintiff's holding company alleged. Well, it also has to be linked, also has to be established that mere having a common shareholding structure or common directors would not be enough. The persons who are employed in the holding company would have to do something directly with the contract and directly with the plaintiff's claim against the defendant. Now, the defendant, what would the defendant have against the holding company? My claim is on account of unpaid price of goods sold and delivered. The defendant has no claim because it has no written statement. The defendant also does not say in the application under Section 8 that he would have some claim against the plaintiff or even the non-signatory. He's only saying whatever is the subject matter referred. So what is the reason for arraying the non-signatory to the arbitration? There is no reason for the defendant. Even if I had presumed that the defendant has a cause of action or has a claim insofar as the price of goods is concerned, the defendant could have said that, all right, there were various other arrangements for which you are not entitled to claim any money. Defendant could have said all that. Even then, would that claim be as against the plaintiff or would that claim be as against the non-signatory? Because non-signatory had nothing to do with the performance of the contract in India. They only ruled out whatever obligation that the distributor has insofar as the market is concerned.
Here, who was the distributor under that distributorship agreement?
The defendant was the distributor.
The defendant was the distributor.
Yes.
So the holding company has entered into an agreement with the defendant.
Yes.
So far the distributorship agreement is concerned.
Yes.
Right?
Yes.
And the plaintiff, with its independent contract with the defendant, sold and delivered the goods.
Yes. And that is provided in the agreement itself. What my learned senior friend has taken your lordships through the correspondence.
Show me that clause.
It takes the application GF4.
Yes. Yes.
At first, kindly takes page 140, where the distributor agreement starts from. Kindly takes page 142.
Yes.
1.1. What is the subject matter of the agreement?
One 142.
Sorry, 142, 1.1, clause 1.1.
Yes.
Subject to the terms and conditions of this distributor agreement, Flint Netherlands grants to distributor a non-exclusive and non-assignable right to distribute the products listed in Schedule 1, as amended from time to time, within the contractual territory pursuant to Article 1.2. What is the contractual territory? It is West Bengal.
Show me what the parties to the agreement.
Yes. At page 140. SAS is the defendant. That's the proprietorship concern of the defendant.
Next.
Now 1.1 and 1.2. These two clauses say that Flint Netherlands is granting the defendant a right to distribute. Nothing further. And the distributor would also have no right to further assign or further transfer his right to distribute. Now takes page 143. What are the obligations of the distributor under the agreement? Does he have any obligation to pay Is it provided under this agreement? It is not. Kindly takes page 143.
143. Yes.
Article 2, these are the restrictions on the distributor.
Yes.
I'll quickly glance through. My lord. Clause 2.1 is without the non-signatory's consent, the defendant cannot indirectly manufacture the products. That is one, nothing to do with the suit. 2.2, distributor will not solicit any orders from any clients other than outside the contractual territory. Nothing to do with the suit. 2.3, the distributor shall not sell the products to any direct customers of Flint. Nothing to do with the suit, not even my allegation. 2.4, nothing herein will be construed as granting a franchisee to the distributor. Nothing to do with the suit. 2.5, any and all other rights not expressly granted to distributor will be deemed to be reserved by Flint. Then, my lord, what are the obligations of the distributor? Because the defendant's obligation to the plaintiff is to make payment for supply of goods. Now, under this agreement, the obligations of the distributor are 3.1, distributor shall buy the products in its own name for its own account. No dispute, not a subject matter of the suit.
No. You are a Flint affiliate.
I am a Flint affiliate.
Distributor shall buy the products in its own name and for its own account from the respective selling Flint affiliates.
Yes. And resell them. So the plaintiff supplies goods to the defendant will resell them in the market. 3.2, the defendant shall sell the products in the contractual territory, then promote distribution of the products, familiarize itself with the products, to monitor continuously the market for the products, to visit regularly the customers, to offer technical support.
That's all right.
Nothing to do with the suit. So the obligations of the distributor, what has been laid down in the agreement, has nothing to do with the due that is claimed by the plaintiff as against the defendant. Now, my lord, kindly takes page 147, clause 7.5. Clause 7.5. Should distributor's financial situation threaten to deteriorate, or should distributor be in default of the payment obligation, Flint selling affiliate may, at its own discretion, request from distributor sufficient.
1 second.
I'm sorry.
Flint selling affiliate may.
Yes.
Read on.
Flint selling affiliate may, at its own discretion, request from the distributor what? First, sufficient guarantee for execution of an order, which I am not claiming. 2, the change of payment terms to cash in advance payments. I am not saying that. And or Flint selling affiliate may suspend deliveries until outstanding due payments have been made in full. That is also not mine.
Kindly come.
Yes.
Sufficient guarantee
Sufficient guarantee before execution.
of an order.
Yes.
Or
in respect to amounts outstanding and due under the purchase agreement.
Under the purchase agreement.
Now, what is the purchase agreement? Purchase agreement is what I've pleaded in the plaint.
Plaint.
Yes.
Wait. Now kindly come. Yes.
So, my lord, this obligation towards the plaintiff, which is existing of the defendant, this has got nothing to do with the agreement. I am not seeking any guarantee from the defendant. I am not even saying that I will stop supply if you don't pay. It's within the scope of this agreement. I am not even saying that change the payment terms, give me in advance, don't pay in cash, etc. I'm not saying all that. So my right to sue the defendant, plaintiff's right to sue the defendant does not emanate from this agreement at all. And conversely, the defendant's right to resist my claim also does not emanate from this agreement. If Flint, Netherlands decides that, all right, I'm terminating your distributor agreement, whatever it may be, then the defendant would have some cause of action against the holding company. But that has not happened in the case.
Yes.
So even if I assume that this agreement exists and defendant may enforce, it could only enforce it against Flint, Netherlands. I would not be a necessary party in that. Well, this is at the outset. I'm saying that this agreement, in any event, even if it is considered, that does not cover the subject matter of the suit, and that is why the Cox and King's judgment would not be applicable, because there is no commonality in the subject matter of the suit here and the subject matter of the arbitration agreement. Then, Malad, the next aspect which this judgment deals with is the consent of the parties. Consent in execution, performance, and termination of the contract. If non-signatory had anything to do with anything,
Take me through the relevant portion.
Malad, kindly takes paragraph 116, internal page 73 of the decision.
Paragraph?
Paragraph 116. This comes after the court places reliance on Discovery Enterprise, where these few factors have been enshrined. Then paragraph 116 may I place. Since the group of companies doctrine is a consent-based theory, so the primary point is consent.
Now, 1 second.
Yes.
Since the group of company doctrine
Is a consent-based theory. Its application depends upon the consideration of a variety.
Consent based on is a consent based theory.
Its application,
read on.
The group of company doctrines application depends upon the consideration of a variety of factual elements to establish the mutual intention of the parties involved. In other words, the group of companies doctrine is a means to infer the mutual intentions of both the signatory and non-signatory parties to be bound by the arbitration agreement. The relationship between and among the legal entities within the corporate group structure and the involvement of the parties in the performance of the underlying contractual obligations are indicators to determine the mutual intentions of the parties. The other factors, such as the commonality of the subject matter, composite nature of the transactions, and the performance of the contract ought to be cumulatively considered and analyzed by courts and tribunals to identify the intention of the parties to bind the non-signatory party to the arbitration agreement. The party seeking joinder of a non-signatory bears the burden of proof of satisfying the above factors to the satisfaction of the court or tribunal, as the case may be. So the non-signatory, the party who is applying, has to satisfy the test that the non-signatory had something to do with the performance of the contract. And the nature of the transactions was such that it was deemed to be composite in nature.
117.
117. Section 7 of the Arbitration Act broadly talks about an agreement by the parties in respect of a defined legal relationship, whether contractual or not. Such a legal relationship must give rise to legal obligations and duties. What are the legal obligations of the defendant towards Flint, Netherlands?
Read on.
In a corporate group, a company may have various related companies. The legal relationship must be analyzed in the context of the underlying contract containing the arbitration agreement. The nature of the contractual relationship can either be formally encrusted in the underlying contract, or it can also be inferred from the conduct of the signatory and non-signatory parties with respect to such contract. However, we clarify that mere presence of a commercial relationship between the signatory and non-signatory parties is not sufficient to infer legal relationship between and among the parties. If this factor is applied solely, any related entity or company may be impleaded even when it does not have any rights or obligations under the underlying contract and did not take part in the performance of the contract. The group of companies doctrine cannot be applied to abrogate party consent and autonomy. The doctrine, properly conceptualized and applied, gives effect to mutual intent and autonomy. Now, these factors, what the Supreme Court says, is not present. None of it is present in our case. Then kindly takes paragraph 119.
Yes.
Paragraph 119 and 120. May I place 119? In Dow Chemical, it was held that a group of companies constitutes the same economic reality, which has to be considered by the arbitral tribunal while deciding on its jurisdiction. According to the tribunal, the presence of the group of companies is merely an additional factor that the tribunal may consider to determine the mutual intention. In Canara Bank, this court did not apply the group of companies doctrine solely on the basis that the companies belonged to a single economic unit. Rather, it was held that there was an implied or tacit consent by the non-signatory to being impleaded in the arbitral proceedings. The presence of strong organizational links or financial links between signatory and non-signatory parties is only one of the factual elements that the court or tribunal may consider to determine the legal relationship between signatory and non-signatory parties. We accordingly clarify that the principle of single economic entity cannot be used as a sole basis to invoke the group of companies doctrine.
In case of next.
Yes, paragraph 120. In case of multiple parties, the necessity of a subject matter and composite transaction is an important factual indicator. An arbitration agreement arises out of a defined legal relationship between the parties with respect to the particular subject matter. Commonality of the subject matter indicates that the conduct of the non-signatory party must be related to the subject matter of the arbitration agreement. For instance, if the subject matter of the contract underlying the arbitration agreement pertains to distribution of healthcare goods, the conduct of the non-signatory party should also be connected or in pursuance of the contractual duties and obligations, that is, pertaining to the distribution of healthcare goods. The determination of this factor is important to demonstrate that the non-signatory party consented to arbitrate with respect to the particular subject matter. Here, this is reverse. In our case, this is a contrary case. The non-signatory had nothing to do with the performance or the payment obligation of the defendant. Then kindly takes paragraph 123.
Yes.
But I'll read on from the last sentence. The unit droit principle of international commercial contract. Lakshmi has found that? Commercial Contract 2016 provides that the subjective intention of the parties could be ascertained by having regard to the following circumstances. Preliminary negotiations between the parties. This much my learned senior friend has been able to satisfy, that yes, there were preliminary correspondences exchanged between the non-signatory and the defendant. Now then, B, practices which the parties have established between themselves, not present in our case. Conduct of the parties subsequent to the conclusion of the contract, not present in our case. The nature and purpose of the contract, entirely different. The meaning commonly given to terms and expressions in the trade concerned. So B, C, D, E, F, nothing is applicable. Only A has been satisfied. This much I would agree. Then, my lord, paragraph 127. 127, the last two sentences.
One second.
I'm sorry.
Hmm.
127, last two sentences. I'll not place the entire paragraph. But in other words, that's the last sentence of page 76. But she has got that page 76, last sentence, last line. In other words, the test is to determine whether the non-signatory has a positive, direct, and substantial involvement in the negotiation, performance, or termination of the contract. Mere incidental involvement in the negotiation or performance of the contract is not sufficient to infer the consent of the non-signatory to be bound by the underlying contract or its arbitration agreement. The burden is on the party seeking joinder of the non-signatory to the arbitration agreement to prove a conscious and deliberate conduct of involvement of the non-signatory based on objective evidence. So commonality of subject matter, intent, conduct of the non-signatory to be bound by the agreement. Here, who is in our case, the non-signatory is the plaintiff. It has not been established that the plaintiff committed some acts which has given rise to this presumption that the plaintiff is saying that yes, I am bound by the arbitration agreement and my right flows from there. Now these are this judgment is about. Three factors: commonality, consent, and intention. None of these factors are present in our case. These are insofar as the judgment is concerned. And also, Malad, if I may point out one thing, Malad, in the Section 8 application, the defendant initially, when this contract was the correspondences were being exchanged, the defendant objected to the arbitration clause and the place of arbitration being in Netherlands. He objected to it. And then now comes and says,
it is neither here nor there.
I'm only saying this to show the defendant's conduct. There are admissions galore, pre-suit, even post-suit.
That is neither here.
That is not the subject matter of the Section 8 application, but still. But these are all my submissions, and all the other 3 points, these are technical points which I had.
No, you give me that 2010.
Yes.
72. একটা ওই পাতা নেবে,
paragraph 29.
আচ্ছা এটা লাগাতে হবে। Paragraph
29.
Repeat the citation once.
2010.
Paragraph
29. 2010, volume 1 SCC, page 72.
Paragraph,
29.
okay.
Only one paragraph. May I place this by a short paragraph? But it is to be noted herein that the claim of the appellant regarding
But,
but it is to be noted herein that the claim of the appellant regarding the dispute was under the arbitration clause mentioned under the original partnership deed and not on the subsequent one. Since the original deed was not filed within the requirement of section 8(2) of the Act, it must be held that the mandatory requirement under the Act had not been complied with. Accordingly, even if we accept that the factum of a dispute relating to the retirement of the appellant under original deed dated such and such, still the court would not be empowered to refer the matter to an arbitrator due to the non-compliance with the provisions mentioned under section 8(2) of the Act. In our case, it has not been disclosed. That is an admitted case, and there is also another application filed by the defendant for production of the arbitration agreement.
these are your submissions.
These are my submissions.
Nothing much.
Nothing more.
You have completed.
Yes.
Yes, only distinction with 2010.
Yes. One paragraph from Cox and Kings, which I felt was, my lord, he cited only, my lord, one para he missed. Kindly takes note, I will not place it, my lord.
Yes. Para.
My lord, he placed 116, 17, 19.
Hmm.
Finally, also takes a note of 120.
Perhaps I have read it. Yes, I have read it.
Yes, very good. Then, my lord, kindly comes to, my lord, this judgment, my lord, 2010. This is arising out of, my lord, an order. Kindly for the facts, my lord, paragraph 1. Order of the Madras High Court dismissing a civil revision, challenging an order by which the district judge rejected the application for appointment of arbitrator. This related to, my lord, partnership dispute. Paragraph 2, my lord, the partnership agreement is referred.
Any section 8 proceeding?
Yes, section 8 proceeding was there. Kindly comes to paragraph 7.
7. Yes.
Respondent subsequently filed a suit being so and so before the court of the district Munsif at Coimbatore for a declaration appellant is not a partner of the respondent number 1 after 18 November 2005, and to prevent him from causing any disturbance to respondent number 1 for its peaceful running by way of a permanent injunction. Appellant thereafter filed an application under section 8 of the Arbitration and Conciliation Act being such and such in the court of the district Munsif at Coimbatore, which was rejected by the order of 7 June 2006. Feeling aggrieved by the aforesaid order, appellant filed a civil revision along with a petition for stay being MP number so and so in the High Court of Judicature and Madras. In para 8, High Court by its order dated 8 January 2007 affirmed the aforesaid order of the district Munsif at Coimbatore, dismissed the civil revision petition and also the petition for stay. It is against this order of the High Court in respect of which the instant special leave petition was filed by the appellant, which on grant of leave was heard by us in the presence of the counsel for the parties. Now, my lord, the distinguishing feature kindly comes to paragraph 14. Counsel for the respondents further argued that the subject matter of the suit was a different one. It was not within the ambit of the arbitration clause of the partnership deed of 7th April 2003, and that the partnership deed had ceased to exist after the firm was reconstituted due to the retirement of the appellant. So there was a reconstitution of the partnership.
That's on facts.
So that's the...
If the suit, subject matter of the suit is different from arbitration agreement,
then
it does not apply.
Does not apply.
But kindly
therefore,
come
trial
to...
court was justified in not referring the matter to the arbitrator. Two more paragraphs I wish to rely upon, 16 and 19.
You answer on that point. 8.2.
Yes. Arbitration Act about it. It is clear from a perusal of the documents that there was a clear dispute regarding the reconstitution of the partnership firm and the subsequent deed framed to that effect. Dispute was relating to the continuation of the appellant as a partner of the firm, especially when the respondents prayed for a declaration to the effect appellant had ceased to be a partner of the firm after his retirement. There is no doubt in our mind that the dispute squarely fell within the purview of the arbitration clause of the partnership deed of 7th April 2003. Therefore, arbitrator was competent to decide the matter relating to the existence of the original deed and its validity to that effect. Thus, the contention that the subject matter of the suit before the first additional district Munsif Court at Coimbatore was beyond the purview of the arbitration clause cannot be accepted. So, Supreme Court negated the findings of the first court as well as the High Court, rejecting the challenge to that
Supreme
order.
Court held 8 maintainable.
8 maintainable. And maintainable because it is really arising out of the first arbitration agreement
8
contained
maintainable.
in the
His
first.
point is why original is required.
Yes, original no longer required. My lord, kindly sees the statute.
His point is 8.2 original. That's all.
My lord, kindly comes to 8.2 once. The application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. This was, my lord, the language. Then there's a proviso inserted. Provided that this judgment lordship is seeing is of 2010. Proviso was, my lord, inserted with effect from 23rd October 2015. Provided that where the original arbitration agreement or a certified copy thereof is not available with the party applying for reference to the arbitration under subsection 1, and the said agreement or certified copy is retained by the other party to that agreement, then the party so applying shall file such application along with a copy of the arbitration agreement and a petition praying the court to call upon the other party to produce the original arbitration agreement or its duly certified copy before that court. Now, I had taken your lordship through the distributorship agreement. I had indicated from the mails that they had said that they would only sign it digitally by my lord, this was a software which was being used, DocuSign. So that is how, my lord, it was signed.
In this case, admittedly, there is no arbitration agreement. In this case,
in
the goods for the goods sold and delivered to you,
yes,
there is admittedly no arbitration
so
agreement.
if lordship is going by the plain case, as he has framed his cause of action, strictly by that, my lord, no arbitration agreement.
I have to go by that.
But
I was the plain case.
if lordship is accepting the principle of Cox and Kings.
No, Mr. Dotto. If I accept the principle of Cox and Kings, then that question comes and that requirement is now diluted. That requirement is now diluted. So I'm really not serious on that.
Yes.
I'm not serious on that issue.
And my lord, there were 2-3 my lord points which he had taken. Section 45, lordship had, my lord, he had taken a point that because one of the party is an international.
He says that if you want to
let him admit that this agreement is there, there is an
he is saying that if you at all have to take recourse to this arbitration clause, then it is an international arbitration.
My lord, if I am taking if I am taking recourse on, my lord, for appointment of a tribunal in an international commercial arbitration.
Don't travel that far in the facts of this case.
Not required, man.
Absolutely. Don't travel that far.
Page 45.
In the facts of this case.
Saying we have not received. এটা পাঠিয়ে দিয়েছে DocuSign. এই ডকুমেন্টটা দেখানো।
The fact that the document, the distributorship agreement was signed and it was sent to the principal.
I admit.
That's there.
It is between the holding company and yourself.
Yes.
I admit that.
But not falling within the plain case. Lordship, possibly what is troubling is that from the plain case, it does not appear that the subject matter is.
And whether the Section 8 criteria are fulfilled in the light of the averment in the plain. That is the test. Nothing more.
Those are my submissions.
Sure?
Of course.
You have completed? Satisfied?
Supply of materials.
That is all.
Ashun.
Grateful for the time, my lord, given.
No. It's a pleasure to hear you all.
May I be excused, my lord? May I take your lordship?
Mr. Saurojit Dasgupta. আচ্ছা, এটা তো একটা কালকের অর্ডার ছিল, দেখি বাবা একটু অর্ডারটা দেখো।
I thought lord.
কি করছো তোমরা? একটা ফাইলও রাখবে না অর্ডারে?
না
Yesterday's order speaks for itself. Paragraph.
Lordship had recorded, I had concluded. He is in the midst of his submissions. He will
Yeah,
continue.
right.
It's for orders.
You've got it in the server.
Yes, it's there.
Ah.
I'm not carrying a copy, but it's there.
এর কোনো ফাইল টাইল থাকবে না? তো দেখো কোনো আপত্তি নেই আমার, দেখো অর্ডার শিট, দেখো কোথায় ফাইল, দেখো কিন্তু হাত মুছে ফেলে দিলেই হয় বাবা, এরকম ঘুরছে একটা অর্ডার। সবে গতকাল আমি আপলোড করে তবে বাড়ি গেছি, সবে আপলোড হলো। হ্যাঁ হ্যাঁ, তাহলে সেটা তো আজ সকালে ফাইলে আসবে। এসব আমি একদম পছন্দ করি না। ইয়েস্টারডেজ অর্ডার স্পিক্স ফর, এগুলো আমি একদম পছন্দ করি না বাবা। হ্যাঁ, যাই হোক, আমি যখন মামলাটা নেব একটা ফাইলে অর্ডারটা করে আমার কাছে যেন থাকে। হ্যাঁ, এটা ফাইলে রাখবে। একটা জিনিস বোঝো, কোনো কারণে এটা এদিক ওদিক পড়ে গেলে কি হবে বাবা? হতেই পারে, সে ভুল তো হতেই পারে যে কারুর। কি বললাম? Paragraph. Today, Mr. Shorojit Dasgupta has concluded his submissions. Full stop. He has also dealt with the judgment cited by Mr. Rajoshi Datta yesterday. Full stop. Paragraph. Mr. Rajoshi Datta then, comma, in reply, comma, has also dealt with the submissions made on behalf of the plaintiff and has concluded his submissions. Paragraph. Parties have concluded their submissions. Paragraph. Judgment stands reserved.
Grateful.
এটা আগে নাও বাবা, একটা সাদা ফাইল নাও, আমার নোটটা রাখো। বাবা বাবা, আস্তে আস্তে, কোনো হড়বড় করার ব্যাপার নেই।
নামগুলো appearance-টা চাইছে।
দিয়ে দিই।
নোট করে রেখে দাও, নোট বললে লিখে দাও। নাও জাজমেন্ট গুলো ঢুকিয়ে রাখো ওই নোটের সঙ্গে। থ্যাংক ইউ।
Grateful.
Yes.
I pay for the defense.
Yes.
So this is, as I had said, my lord, there are two applications. One is both by us, one for injunction where it was heard extensively and an interim order was passed last year in December, 16th of December. Now it has been extended from time to time, no appeal. And the other is a perjury application filed by us, which is appearing for the first time. The issue, I mean, there will be some overlapping issue as to whether there's a deliberate false statement at one place or not.
There's one application at my instance also.
Yes.
Yes, there's one application at my instance also for acceptance of the written statement, which has been filed within the 120 days period, but on the 68th day. So I've taken out that is GA3. That is my application also before your lordship.
So any demeral or something? No, you're filing written statement.
We have filed it already. We have served copies, but the application is pending.
You can dispose that.
You have filed before your extension application has been filed.
No, lordship. The extension, no, lordship. There were extensions. Thereafter, the plaint was served.
No.
Lordship.
When did you file your written statement? Before your extension application has been disposed of?
Yes.
Liberty.
Liberty.
Because
Yes. There was a liberty.
the previous judge used to,
Yes.
when someone moved an application for extension, his lordship would give time to further the, I mean,
No, not
without
only that. I
rights.
have also seen one when the application was not even the board.
The last day is coming, maybe application file something, because otherwise by the time the application,
How can I do that? I do not know. The language of 12A
No.
I'm sorry, order 8.
Without prejudice, because if 180 days expired in the meantime while the
The
application is
party
being
will
heard.
suffer. The party should come up at the right time, at least some day before.
Yes, but the hearing may not happen. So that's why the
That is
court
it.
would be given.
No, but
I'm supporting his
under
case for the bar.
which provision? That's my question. Yesterday I passed an order where incidentally, before allowing the application, leave was granted to file
Subject to
witness
the
statement
outcome.
subject to the outcome.
That's
right.
what usually was being done.
Yes. Yesterday, and the written statement has been filed in the month of July or something. I allowed the application yesterday. That's why I added one sentence in the order. This order shall not be treated as a precedence.
That is
Your lordship is saying is absolutely the right.
I have delivered my judgment, which is uploaded. It's a detailed judgment, quite longish. That yes, when it can be allowed and all. That's a different issue. But
It is a similar case. I filed it in June 25. The applications as well.
কালকের অর্ডারটা দাও তো, আপলোড করেছি, দাও আমার ফাইলটা দাও, আজ ফাইলটা। না কালকে আপলোড করেছি, কালকে একটা আপলোড করেছি। In one matter, the one which I've delivered a longish judgment, that on that day itself was the last day. So
That's how it could be, no doubt.
No, I allowed the application on merit. Then I extended the time to file written statement till 6:30. Justice has to be done, but how can I stretch my hand where I'm not
Justice
permitted?
Rao's logic was 120 days, somebody has time.
Yes.
Let's take about 3 months plus
Yes,
20,
yes.
120 days. So he can come up to the 120th day and say, I
Absolutely.
want to file. So if he comes on the 120th day,
I don't mind.
Just because the application can't be heard on the 120th day, whether his rights or her rights are
that is the diligence should be there on the part of the party.
So then the 120 days get truncated to 90 days or 70 days because approximate court time for hearing. So
No, if an application is pending, even for 300 days, I don't mind. Act of court cannot harm a litigant.
That is the law. That is
Act
the law.
of court cannot harm a
If that is
litigant.
done, then his problem is
But no
solved.
application was on the board.
Then no question. If the application is not on the board, then there's no question.
আসুন, কালকের একটা অর্ডার আছে, বের করো। দেখো ওই ইয়েতেই থাকবে, নিউ চেম্বারেই থাকবে। অ্যাপিয়ার করলো। পেয়েছো? দেখি, দাঁড়াও পড়ি। হ্যাঁ, 50,000। ইয়েস, দাও এটা প্রিন্ট আউট দাও তো। কালকে আপলোড করেছি তো, হ্যাঁ কালকে সই করে আপলোড করে গেছি আমি। So first let me decide that application. হ্যাঁ, এটাই, এটাও এখানে রেখে দেবে। Yes, show me the application. কোনটা?
A3.
3. এটা কি? Written statement is voluminous.
Yes, sir. In 3 volumes, or maybe 4.
Which are the relevant paragraphs?
From 3, the date of receipt of the summons was on 17/4/2025. Next 3 days, 18/4, 19/4, 24 were Good Friday, Easter Saturday, Sunday. Lordship, and the defendant could not verify the postal article till 21st. Lordship, from 25th to 4th of May, it was on my ground that I was traveling, so I could not take time. Thereafter, Lordship, on joining back work, some instructions were required. In May, there were holidays. Exchange of instruction took place. Thereafter, there was a summer vacation, Lordship. During that period, it was prepared. Thereafter,
আসুন। How many days delay?
38 days, beyond 30 days. 38
Paragraph 2
days.
তে লেখো 38 days. Bold. Bold লিখে রাখো, আমি বলে দেবো। Bold, এই আরেকটা প্রিন্ট আউট দাও তো। 38 days, ঠিক আছে, beyond 30 days, তাহলে তুমি বুঝতে পেরে যাবে। Writ of summons was received on
17/4/2025.
April 17, 2025. Bold করবে ডেটটা। When it was mentioned and granted leave to accept the written statement?
It is, Lordship, I was trying to check up whether there was an order to that effect, but I have found that there was no order. but the
Endorsement on the fiat is there.
Yes,
So you should be in your note that on such and such date.
I was wanting to ascertain that, but
Not on your fiat. You
Sorry.
must have an endorsement, council endorsement, or your own endorsement.
Lordship, it is seeming as if 24/6/2025. Lordship, this is the endorsement.
Acha. Leave was granted by the coordinate bench on
Or 20, it is
August,
25.
September.
No, Lordship, it is June 2025.
Give me the date.
It is seeming on from my record that it is 25/6/2025.
June 25, 2025. এটা paragraph 3 তে ডেটটা চেঞ্জ
This
হবে।
might be a little erroneous on my part.
When your application has been filed,
Lordship, the application has
it
been
was subject to the outcome.
Yes.
Subject to the outcome of the application.
Lordship, the leave was a general leave, not mentioned. Lordship, but ideally it is subject to the
No, but what is the date of filing of your master summons?
master summons was also taken out on the session 25/6/2025. That is that I'm aware.
তারপর এটা প্যারাগ্রাফ 4 এর 3 তে ওই ডেটটা রাখো। তুমি জাস্ট প্যারাগ্রাফ 3 তে ডেটটা বলে রাখো। 3 এর এগেইনস্টে ওই ডেটটা হবে। 4 এর এগেইনস্টে ডেট হবে সেম, জুন
2025. 25th June
জুন
2025.
25, 2025, প্যারাগ্রাফ 4 এ। আচ্ছা, প্যারাগ্রাফ 5 এ সেট আউট করো প্যারাগ্রাফস 3 TO2 8 from the written statement. আমি কোট লিখে রাখছি, কোট, ঠিক আছে। জাজমেন্ট ফর্মে হবে, জাজমেন্ট হিসেবে আপলোডও হবে। এই এটা ওকে ডাকো কম্পিউটার। এগুলো জাজমেন্ট হিসেবে আপলোড হয়েছে তো? আপলোড হয়েছে তো? ঠিক আছে, জাজমেন্ট হিসেবেই আপলোড হবে J2 ফর্মে, ঠিক আছে, লিখে রাখো দরকার হয়। আচ্ছা, নেক্সট হচ্ছে এটা কত, 3 to 8। হ্যাঁ, প্যারাগ্রাফ 5 না, দাঁড়াও দাঁড়াও, প্যারাগ্রাফ 5, হ্যাঁ, সেট আউট 3 to 8. তুমি এটা নিয়ে যাও, দেখে বুঝতে পারবে। একটা সময় কাছে রাখো, দাঁড়াও। 3 to 8, ঠিক আছে? Then 6, 7, 8. 9, 10. না 10 না, 9, 6, 7, 8, 9 সেট আউট ওই অর্ডার থেকে। Then 10, 11, 12. ঠিক আছে? 13টা রাখবে না, লেখো নো 13, লিখে রাখো। ওকে, subject to payment of 50,000.
Lordship will kindly
Next.
consider
No.
that.
That I will not consider. এটা এখানে গুজে রাখো। Yes, proceed. This is GA in re GA, madam?
3.
GA com, IA GA com 3 of 2025.
Lordship,
ঠিক আছে?
may I pray that it may be the cost may be considered, Lordship.
আরে লেখা রয়েছে 2025 যে
Because
অ্যাপ্লিকেশন 25 তো।
হ্যাঁ,
এই তো
2025. GA
হ্যাঁ, লিস্টে ভুল আছে। এটা কত নম্বর? সিরিয়াল 6 তো।
হ্যাঁ।
হ্যাঁ 25ই তো আছে। ঠিক আছে,
আমাদের cost
ডিসপোজড অফ, ঠিক
payment-
আছে, ওই অর্ডারেই লেখা আছে। শুধু ওই একটা লাস্ট বাট ওয়ান যেটা প্রেসিডেন্স হবে না বলেছিলাম, ওইটা কেটে দাও, বলে দিচ্ছি তো, ডিলিট প্যারাগ্রাফ 13। নেক্সট।
may I-
ইয়েস, ইয়েস মিস্টার মিত্র।
This is a matter, but this is a general.
ম্যাডামের নাম দিয়ে দেবে, মিত্র সাহেবের নাম দিয়ে deবে। ইয়েস।
But this involves, Lordship, this is a, Lordship, I will, without touching my brief, let me tell you, Lordship, there is a MSME scheme, Lordship may have come across, for restructuring of,
Setting up on restructuring.
for revival of MSMEs when they are when they are in the process of becoming an NPA or thereafter. The banks have to form a MSME committee. The MSME committee will have to all matters
This I'm hearing your which application?
by injunction application.
Acha. So let there be a direction on perjury.
They should not perjury.
So one by one, then I will come so that I can devote some time. Ashun, next, come on, tell me. IAGA
4.
IAGA 4 একটাই অর্ডার শিট করবে, সবকটা ইনরে করে করতে যাবে, ঠিক আছে? নাকি ওটা আলাদা সিরিয়াল নাম্বার আছে? একটাই সিরিয়াল নাম্বার, ইনরে IAGA 4 of 2025 paragraph. This is an application filed by the plaintiff under section 395 of the Code of Criminal Procedure Code.
বদলে গেছে তো for pending proceedings এ বোধহয় এটা কি pending proceeding
সুট তো চলছে।
মানে এটা কি নাই, ওটা আছে আগে না?
জুলাই 2024 এ এটা তো প্রসিডিং
করা যাবে তো? তাহলে এটা সেপারেট করো, ওই জিএ নাম্বার দাও, ওই ইয়েটা দাও, কস্ট টাইটেল দিয়ে এটা সেপারেট অর্ডার করো, জিএ বলে, IAGA ইনরে, ঠিক আছে?
পিটিশনে লেখা আছে the copy of CRPC read with 379 of
Filed under section 340 of the Code of Criminal Procedure 1973.
Now section 397.
Under presently section 379 of BNSS 2023. Full stop. Paragraph. Mr. Abhrojit Mitra, learned senior advocate, appears for the plaintiff. MS
Deblina Lahiri,
Deblina Lahiri, learned advocate, appears for
defendant, sole defendant.
Respondent,
And the
respondent.
respondent.
the respondent bank. Full stop. Paragraph. There is no scope for any interim order. Now, the records have to be kept with the registrar. Yes, yes. No scope for interim order. 7, except that the registrar original site shall keep the record of the suit
And the application J1.
and the original record of the suit along with IAGA Com 1 of 2025. 2024 in its safe custody until further direction. কি বললাম? Learned register original site. Until further direction. Paragraph. The respondent shall file affidavit in opposition.
2 weeks time, Lordship may seek.
আজকে কত? By December 10, 2025. Paragraph. Affidavit in reply, if any thereto, shall be filed by January 14, 2025. The matter shall appear under the heading adjourn motion in the monthly list of February 2025, 2026. এই আগেরটা 2026 February 2026 and পরেরটা হচ্ছে monthly list of February 2026 adjourn motion. Yes, বসে পড়ো। এইবার GA Com 1 হবে। হ্যাঁ, দাও। Affidavits complete.
The interim order is till 14th, so that's why we mentioned. And now, my lord, what MSME scheme for
Opposition reply টা দিয়ে দাও। Yes.
RBI scheme? What is relevant here is that MSME scheme contemplates an MSME committee of each bank at different regional office level or each bank level. So there has to be MSME committee. Whenever an account becomes SMA2, that is 30 days, that is more than, yes, SMA2 is 60 days plus 61 days overdue. There has to be a referral made to the MSME committee by the bank or by the lender for a corrective action plan, for deciding a corrective action plan.
Yes.
Now, this corrective action plan
Yes. Yes.
Under the committee will have the power to restructure, and for that purpose will follow the CDR, the corporate debt restructuring mechanism under the RBI guidelines. And there can be a techno-economic viability study for restructuring. The committee may also decide that some recovery may be required. In that case, that will be the decision taken. But it has to be decision has to be taken following the scheme.
Yes.
Now, my lord, this has received the consideration of this court whether SARFAESI proceedings can be whether an NPA can be declared without following the procedure, and if followed, what is the consequence? Should it be quashed? Because the NPA has consequences as in 13.2, 13.4. For the NPA declaration,
Here the SURFACE Act has been invoked by the blank.
we have challenged the NPA jurisdiction, by NPA determination. There are judgments in suit as well as writ court, suit by a division bench, that when you challenge the NPA, that is the source of this action, suit will also lie, because that is not challenging 13 to 13.4. It is not hit by the surface.
No, no. But the source, but the reason for 13.2 is NPA. Unless NPA, 13.2 cannot be invoked.
That unless loan given, unless recovery, so many considerations.
So all these points cannot be raised in 17.
Well, whether it can be raised or cannot be raised, that's a different matter. But then it can be raised in a suit, because the NPA, when you're challenging the declaration of NPA as contrary to RBI guideline, then a suit will also lie. So our suit is for that. In fact, when the suit was filed, the prayers which were hitting section 34, the court had them deleted while presenting the plaint. So those which will be hit by 34 were all deleted. So the plaint became one pristinely. You see the order admitting the when the suit was filed. Press C, which would have been hit by 34, we had to give it up. Lordship will see the order of 26 November 2024, 26 November.
The 26 November.
26 November order, the court has dealt with this issue. That is why they have also not filed any demurrer and dismissal. 26 November 2024. Hey, order.
So tribunal is proceeding.
No, the effect of the interim order, it's a different matter.
What
the
is
effect of the interim order is there.
What is the interim order?
There is an injunction granted
that they will not give effect to that letter of 6 December 2020.
Tribunal is
They will not give effect to the letter of 6 December 2024, of yes, and 11 January 2025.
Mr. 6 December 2023.
That NPA notice has been stayed. So the effect will be that they cannot sell my property.
no, not only that, the OA has also.
Wait.
Who has been adjourned? It has been adjourned.
Where is the injunction?
That is the order passed on
16th December
16th December 2024.
আমরা ডিসক্লোজ করেছি আমাদের একটা সাপ্লিমেন্টারি অ্যাফিডেভিট আছে ওটার পেজ 9
No, জজের ফাইলে থাকবে। In fact, our division bench has also held that way, that this NPA declaration is bad, that suit will lie. So long as the consequence may be many. There may be a check dishonor case also getting stayed. Here it is not so. Consequences may be many.
Steps taken by the calculator that that is the DRP's jurisdiction. So steps before 30 can be challenged.
It can challenge. Will challenge. Copy আছে চেল্লু অরিজিৎ এটি
Yes.
There are several other judgments also, may not be MSME, but where the mortgage injunction being granted not to deal with the property for which 13(4) has been issued by the bank has been upheld by the court. By going to the core of the jurisdiction, say for example, creation of mortgage, you challenge the creation of the mortgage, where even though 13(4) has been issued, the court, I have got several judgments. But So here the issue is whether the Reserve Bank of India guideline has been followed.
Now, Mr. Mitro, sir, whether the guideline has been followed or not, that is your challenge in the suit, right? So it requires a detailed trial. Documents are required to be read. Witness action are required. Whether those documents are correct, entries are made correct. It's absolutely at the end of the day a suit for accounts.
Whether they have followed the procedure of referring
That's
to
right,
the
that's
MSME.
right, that's right. To come to a conclusion that they have arrived that it is an NPA, allegedly an NPA, you have questioned that decision-making process as well as the conclusion. Naturally. So the moment it is a commercial litigation, so the moment you have questioned that, it requires a detailed trial. For that, whether commercial, whether not, does not matter. The procedure of law. It requires a detailed trial. Show me that notice which has been stated. Which page?
The 6th December. 117 of the petition. 117. Second volume of the petition.
Page.
My loan recall notice. My loan recall notice, which contains
117.
Yes.
Yes.
Okay.
Kindly come to 118.
17.
117. 117.
Not volume 2.
Of the petition. May not be the that may be the opposition given to it.
Ule baba, কত বড় opposition.
At 118, last paragraph is what has been really challenged. 118, last paragraph. Last paragraph 118. You have used and utilized the force agreement but failed to comply with the terms and conditions of the same and failed to repay the loan amount as per agreed, as a result of which the aforesaid loan account is classified as a non-performing asset, and as such there is due and out. And as such there is due and outstanding in the aforesaid loan account as follows.
So the moment this is under challenge, the practical side is 13.2, 13.4 effectively state.
If this notice is stated. For that, I have to satisfy the court prima facie that the MSME procedure has not been followed. I have to show prima facie that what is the procedure, laid down the guideline, and whether they have followed that or not.
Sir, even if you satisfy prima facie, on prima facie case, an injunction has been passed. On a prima facie finding, an injunction has been passed, which in effect has stalled 13.2, 13.4, which in effect has stalled section 17. OA.
17
recovery.
17 has not been filed.
Oh,
Yes, it has
that's
75 pages.
19. They have also.
I'm sorry,
filed
19, 19, not 17,
Yes.
19.
Okay, under 19.
19 there is
Recovery,
for that NPA is not a must because
not a must.
because
Absolutely.
19 may proceed because without NPA also 19.
Yes. Just a recall notice, you have defaulted, matter ends.
So NPA is not dependent on NPA. So
That's
19.
right. That's right.
20, if they feel that way, that is not so.
That's right.
Most respectfully, the order says not to give any effect to this notice, which is part of the cause of action in OA. And therefore, the adjudication, the learned tribunal has passed an order wherein he records that since the adjudication of NP itself is under consideration, this matter is adjourned. That is,
Because Lordship clarifies
so
that,
today they
because
have-
legally I cannot say that because NPA is not a precondition for
Absolutely, for section 90.
90.
but this non-recall notice also comes into within the rigors of this order, because it is the notice which has been stayed now.
That will also, yes.
Not only that,
And the section 17 has been
the
filed.
moment 13.2 and 13.2 has been invoked, by operation of law, you are injuncted. The borrower is injuncted or the guarantor is injuncted from dealing with the securities
Statutory effect of.
by operation of law. So today, those injunctions are there.
Should be the because there's no injunction order as such. That is the section in the
This
statute.
is the by operation of law.
13.2, so long as it is not squashed, that has to be there.
That is by operation of law.
Yes, yes.
That is by operation of law, I said.
Right. So
I said
that unless it is squashed, 13.2
absolutely.
will be there.
I said by operation of law.
My lord is absolutely right.
By operation of law. Little that I recollect after before 6 years, whatever was done.
Lordship has not done the bank matters in the last 6 years. 6 years, Lordship is judge.
5.5.
How time flies.
So the question is, by operation of law, you are injuncted.
Yes.
Perhaps 39 or something. 8. So that is there. Now question is, it is equally a commercial litigation. Default has been alleged. What is threshold is troubling me, an unconditional injunction.
I knew this will be coming from a lordship. That is where the MSME guidelines become important. Injunction is there, I can't even prove the property. MSME guidelines specifically provide that there will be no recovery. But there will be a corrective action, restructuring will be done. So if I have to secure or deposit the money, then that will be contrary to the pith and substance of the MSME guideline.
No, not at the interim stage, sir. I tell you why. Of course, subject to hearing both of you. If a condition is imposed, that you secure the debt with the registrar.
My property is there already, so that security is there.
Even if.
Double security, yes.
Even if.
Additional security.
You secure the debt with the registrar, which shall abide by the result of the suit. Which shall abide by the result of the suit. Because the finding of a suit cannot be taken that it shall succeed. It may not succeed. It may not succeed. If it does not succeed, bank will take back the security, adjust its amount from the security. If you succeed with interest, it will go to you, because the entire basis of the claim of the bank will be demolished. Right? Sitting in a commercial jurisdiction, this unconditional enjoyment of an injunction, equity will not also permit.
On that score.
And OA will proceed in its own way, the section 19. That's right, sir. That's right, sir. Because of this injunction, in effect, 13.2, 13.4 has been stayed. In effect. Let us be candid.
Because yes, without, if the NPA is bad, then NPA is the precondition for
provision is under 2.0 or something.
That is 13.2 itself says. 13 itself
whatever.
says
No, NPA is the precondition for exercise.
2.0 is the definition, right?
এখনো ভুলে যাইনি. So 2.0, unless satisfied, there are 3 conditions principally for declaring NPA. That whatever. So Unconditional enjoyment of
Injunction. Worship, I will place it.
you don't have to pay to the bank. You have to secure with the register on your side.
That will I will approach this from the legal side and also the equitable side. This part. May I come to the equitable part first? My securities are there, which the bank has taken. I am not getting back the title deeds.
Sir, securities which are there, Mr. Mitro, today
They can't sell and recover the money.
And today we do not know what is the worth of it as of date. Many cases with your vast experience you have seen.
Not the case made out in the opposition that the security value is
There
less.
lies the equity. There lies the equity.
If that question came up.
All right.
Well,
let me see.
So, on equitable perspective, that is number one. And number two, the mixed equity and law. Unlike a dispute as to the amount due, this is not a case of dispute as to the amount due. Not a case. So that at least there is a claim.
That's the consequence, sir. If this notice is kept in force, then the amount due automatically will be there. 13.2, 13.4, everything will be there. But since the moment this 117 has been stayed, unconditional, unfettered enjoyment, I will not permit.
That can be, well, I will tell you why now in law, that is a difference from an ordinary commercial dispute case or an ordinary bank outstanding dues. You secure because your dues are there. Because of the scheme, MSME guidelines.
But that is under trial, sir.
Lordship,
to apply.
Lordship, because trial is because here this is at the threshold stage, no doubt. But this is not a case of accounts being taken because amount due is not in challenge here. I cannot challenge that. That's beyond the scope.
Whether the OTS term used for you is correct or not.
OTS term is not.
I'm sorry. That's OTS now.
NPA.
I'm so sorry.
NPA.
So to come to a conclusion, to come to a finding that it is correct or that it is not correct, both way. Huge exercise has to be done. Suit is pending. Suit has to
Possibly
be
not.
tried.
Well, I'll tell you why. Because of the guideline. That's why the writ court has entertained. Because writ court, when it entertains, it also doesn't have the benefit of a
Summary
trial.
proceeding.
Summary proceeding. Writ court has repeatedly entertained and sent them back to follow the guideline. Because summarily, if it can be shown to the court that the MSME guideline has not been followed, then the recourse for them that the bank is not remediless. The remedy of the bank is to follow that guideline, go through the procedure, restructuring by the MSME committee, if it's possible, work it out, do the TV study.
Yes.
And if it is not,
at the end of the day, fact remains. As I said, had it been a case before commencement of Commercial Court Act, view of the court may be different, little.
it's the same.
Yes.
So far as commercial court, it's
So
a procedure.
today the fact remains, default is there of a substantial amount. That is the fact.
Default is
It
there.
may not be as on date.
No. Well, I'm not joining issue with them on the default. I'm not joining issue with them. In fact, I have to accept their default case.
Absolutely.
Without accepting the default case, I
cannot
cannot
challenge NP.
I cannot come under MSME scheme.
Right.
NPA, I'm not challenging. I'm not saying that the NPA, it is not NPA. It becomes NPA under prudential norms. But there is but there's another guideline, which is a special kind of guideline applicable to MSMEs, which says SMA 1 means default. SMA 2, another 30 days add. Default. So default has to be admitted. So I will go on the basis that there has been default as per the a plaint case and on basis of the defendant's letters. On that default happening, if it is an MSME, the bank cannot seek recovery. So that's where I will have to establish prima facie to my lord MSME undisputed, because this is a registered MSME. So whether
I am not on that, Mr. Mitro. I accept the for the time being, let me accept the prima facie view taken by the coordinate bench. Let me accept that the prima facie
but then
view.
they cannot seek recovery at all without first following the restructuring, so that the MSMEs survive and they can run.
You have to show your bona fide. That yes, I am ready to make good of the default.
But if I had the money, then there would be no question of restructuring.
No. And then you have to show the bona fide that yes, I have the money.
I don't have
not
the
a case. No, it is not a case that I am a pauper or I am an insolvent. But
I'm saying I don't have the money, but the security is here.
But the way you have taken steps is bad in law. That has to be quashed.
If I have the money, my money is generated through business. So if I have the money, so if I have to take out 12 crores or whatever amount Lordship says from out of my business, that will go against, that will be contrary to MSME guideline.
No, I'm saying that you have to secure it.
So money goes out of the working capital of my business and comes to a different forum.
Sir. Unconditional stay is not permitted in this fashion. An unconditional stay, they are declining the bank not to proceed with SARFACI precisely. That's the underlying effect. Not to take any steps whatsoever with regard to its security. These are the underlying effects.
As the Lordship said, Lordship will give me the opportunity to try to convince my lord on the basis of judgments that in the MSME cases, the courts do not require security, but simply directs the bank to follow the procedure. And if they follow the procedure,
sir, the moment I will say, the court will say, you follow the procedure, then the court accepts at the threshold that procedure was not followed. Then the suit is become partly decreed.
But as an equitable measure, because the equitable measure under the scheme contemplates, and as an equitable measure, if they, for the time when the suit remains pending, if they're directed to, that will be my endeavor. I will show from judgments passed in suit courts, that the remedy will be for them is to follow the procedure which may hold it back. And then they can recover. My suit may remain, but the interim order is the one that is in question.
I am, to be very candid, sir, I am absolutely on this blanket, that my conscience is speaking there.
But why? Sorry, I can't ask a question. Well, but this is not blanket. I cannot get my properties back. I cannot. So my properties are stuck. Their securities are stuck with them. So I cannot get my property back.
That you have vast experience that ultimately it may fall out that the securities are 30% of the total due.
Lordship, my lord is on pleadings. My lord can't go beyond what is on record.
Absolutely
So if it is not the case of the
That's why
defendant,
I'm saying I will stand by the injunction only to the extent of a modification, and you have to deposit with the registrar. Enjoy the injunction.
No, my lord, it is not. So going by the case on record, the security is sufficient. Because lordship will have to, most humble submission, lordship will never have to, but then the courts are bound by what is on record pleaded. If it is not the case pleaded by a party that the security is now become zero or worth half the value, so I would humbly beseech your lordship not to go in that line to see whether the security is depleted or not. Because the bank was itself going to recover its dues by selling the securities.
That's right.
So it's recovering the dues. Recovering the dues by selling the securities.
But that road is blocked. That road is blocked today in view of the injunction.
Unless they of course get the Section 19 certificate, they can of course do it.
19?
So
Yes.
so no one is stopping them.
No, that 19 is there. Let them proceed
19
with
get
the
the
19.
certificate and
Let them
then
proceed.
execute it, so they can sell my properties.
That's a different.
So 19 they can execute and get the property sold.
The moment the law is settled, both 19 and 13 can run parallelly.
But 13 in case, but 13 is conditional upon. Every 19 case is not 13.
No.
So 13 is conditional upon an NPA. And NPA in this case, normal case, it is conditional upon the prudential norms, 30 days, 60 days, 90 days. Without that, doesn't become NPA. So if one files a section 19 and then immediately gives the 13-2 notice, and I come and show that yes, I'm overdue, but it is not yet 90 days overdue. The NPA is bad. Whether the court will say you secure the amount.
First of all, that point you can take by way of section 17. First of all, you can take that point by way of section 17, which is a statutory remedy. Maybe the suit may not be absolute bar. Maybe, as you are arguing. But can these points not be taken up in the suit, in the section 17 proceeding?
But section 17 proceeding, I will show whether the 13-4 measures are being rightly taken up.
Right.
13-4 measures. I will show some judgment, but not
the basis. If you challenge the NPA, the basis of issuance of 13-4, that is also can be taken under 17. 100%. 100%.
Well, may I take it that I have both the options available? But so long as section
34,
9, section 6,
then 34 may hit.
34 may hit if I am directly challenging the 13 to 13-4. Then if I directly, so if there's a jurisdictional fact.
But sir, if you file the suit without even challenging let's say 13-3, 13-4, like this suit, but in effect 13-3, 13-4
that
is
I will
stopped.
show several judgments where the courts have held, our High Court, division bench, single bench, that in effect 13 to 13-4, if it goes, that in no way section 9 CPC jurisdiction of the court can't be taken away unless there is a statutory bar. That is why, my lord, any claim by a borrower against the bank for recovery, even though I have a right of counterclaim, I can still maintain a suit because of the Nahar Corporation, several judgments.
No, but those are now, yesterday I was cited one judgment in a matter. Those points are now diluted by the Supreme Court recent judgment.
VCK is there.
Bank of Rajasthan.
Says it can be. Yes,
Bank of Rajasthan.
That says it cannot be a bar. Suit cannot be a bar.
Suit
Just
cannot be a
because
bar.
one has the option of filing a counterclaim doesn't mean suit is a bar. Even though the DRT has the power to decide a counterclaim.
Suit
That
cannot
is
be a bar.
nothing but a counterclaim is nothing but an independent suit.
Yes, but the moment an injunction has to be passed in the light of the facts or argument as of now, I have heard, as of now, condition has to be imposed.
That is what your lordship. I will try to persuade my lord to.
I'm coming within 7 minutes. Yes, sir.
May I show the scheme first? May I show the MSME scheme? That's the source. লাগানো আছে MSME scheme টা তোমার তো দেয়া আছে we hand up a copy of the MS
It's not part of your application.
This is not annexed, but this is referred to in the body. 16. It kindly comes to the first page, the 17th March 2016 letter of the RBI. Kindly come to paragraph 2 of this letter, that is the code. While the prudential norms on income recognition, asset classification, and provisioning pertaining to advances will continue to be as per instructions consolidated in the Master Circular on IRAC, July 1, and as updated from time to time, the revival and rehabilitation of MSMEs having loan limits up to 25 crores will be in terms of these operating instructions. Restructuring of loan accounts with exposure of 25 crores will continue to be governed by the extant guidelines on corporate debt restructuring. Joint lender forum mechanism. The revised framework supersedes our earlier guidelines. This is the RBI's covering letter.
Loan limit of 25
Up to
crores.
25.
So up to. Yours is covered.
Now, Lordship kindly comes to the main paragraph 3.
Yes.
In order to enable faster resolution of stress
in paragraph 3 of
the guideline, in the main guideline, committees for stressed micro, small, and medium enterprises.
Yes, Mr. Hitzberg.
In order to enable faster resolution of stress in an MSME account, every bank shall form committees for stressed micro, small, as per following arrangements. All banks having exposure towards the MSME sector shall constitute a committee at each district where they are present, or at division level or regional level. And the composition is in 3.3. I will not trouble my lord with the composition. And now paragraph 3.5, all eligible stressed MSMEs shall have access to the committee for resolving the stress in these accounts in accordance with the regulations prescribed in this framework. Actually, what we are really concerned with 4. Application, which is mandatory. Application to the committee for a corrective action plan. Now, this corrective action plan, I will show, my lord, includes restructuring. 4.1. Any lender on identifying an MSME account as SMA2. Now, Lordship, may I go back to paragraph 2.1? SMA2 means a defaulter. 2.1.
Yes.
SMA0 is overdue. SMA1 is principal or interest amount overdue beyond 31 to 60 days. SMA2 is principal or interest amount overdue between 61 to 90 days. So in that case, so when there's an overdue, there's a default admittedly. On coming back to 4.1, any lender on identifying an MSME account as SMA2 or suitable for consideration under the framework, or on receipt of an application, here it is both, my application plus SMA2, shall forward the cases having aggregate loan limits beyond 10 lakhs to the committee for convening of meeting and deciding on a corrective action plan, CAP. Stressed enterprises having aggregate loan limits above 10 lakhs can also directly file an application for CAP to the committee or the largest lender. Now, Lordship kindly comes to 4.2 when an application is filed. Where an application is filed by a bank, that is 4.1, or lender, 4.1, and admitted by the committee shall notify the concerned enterprise about such application. within 5 working days and require the enterprise to respond to the application or make a representation before the committee and disclose details of its liabilities, including liabilities owed to states, central state or central government, unsecured creditors, if any, within 15 days. Provided that if the enterprise does not respond within the above period, the committee may proceed ex parte. So CAP will be ex parte also. On receipt,
So
the
it is the
4.3.
obligation on the committee to consider, irrespective whether the lender joins or not.
So to and consider what?
Lender, not borrowers.
Borrower joins or not. What consider for deciding, that's 4.1 fourth line, for deciding on a corrective action plan. Now I can jump and go to show my law straight away what is the corrective action plan before I come back here. Paragraph paragraph 5. So what? So assuming this is so motor, I'll come back to 4.3. 5. Corrective action plan by the committee. The committee may explore various options to resolve the stress. That is not
where?
5. Corrective action plan by the committee. That is whether suo motu or on the application. The committee may explore various options to resolve the stress in the account. So this can't be by paying money. The committee shall not endeavor to encourage a particular resolution option and may decide the cap as per specific requirements and position of each case. While techno-economic viability of each account is to be decided by the concerned lenders before considering restructuring as caps for accounts with aggregate exposure of 10 crores and above, the committee shall conduct, like in our case, shall conduct a techno-economic viability study before finalizing the cap. During the period of operation of cap, the enterprise shall be allowed to avail both secured and unsecured credit for its business operation. Now, you can see 5.3. Options under cap. The options under cap by the committee may include rectification, obtaining a commitment, specifying actions and timelines from the borrower to
restructuring, recovery. Once the recovery, let's come to recovery because you have suffered a recovery notice.
What you referring to? Which para?
C.
B.
Once the first two options A and B above are seen as not feasible, so they have to apply their mind on A and B. Right?
Then only they can come for recovery.
Absolutely. So recovery is the
conditional upon the A and B.
Conditional upon A and B.
As not feasible. So they have to A and B not feasible, then due recovery.
So application of mind has to be there that A and B has not worked out. Since they have not worked out, now go for recovery.
Now kindly Roshi comes back to paragraph 4.3. What is the procedure they have to follow for arriving at a decision, either rectifying or restructuring? One is that 4.2 within they will call or they give notice for representations, etc., and disclose assets. 4.2. Then 4.3. On receipt of information relating to the liabilities of the enterprise, the committee may send notice to such statutory creditors as they are disclosed by the enterprise, as it may deem fit, informing them about the application under the framework and permit them to make a representation regarding their claims before the committee within 15 working days of receipt of such notice. It is mentioned here that these information are required for determining the total liability of the enterprise in order to arrive at a suitable cap and not for payments of the same by the lenders. 4.4. Within 30 days of convening its first meeting for a specific enterprise, the committee shall take a decision on the option to be adopted under the corrective action plan, as given in subsequent paragraphs, and notify the enterprise about such a decision within 5 working days. This is a quick procedure. So this is not 5 working days from the date of such decision. After the 4.5, if the corrective action plan decided by the committee envisages restructuring of the debt of the enterprise, the committee shall conduct the detailed techno-economic viability study the viability study and finalize the terms of such a restructuring in accordance with the extant prudential norms for restructuring within 20 working days. And within 30 working days, if it is 10 crore to 25 crore, ours is 30 working days. And may notify the enterprise about such terms within 5 working days. Then 4.6, upon finalization of the terms of the corrective action plan, the implementation of that plan shall be completed by the concerned bank within 30 days. We have not come to that stage here. Now 4.7. Where an application has been admitted by the committee in respect of an MSME, the enterprise shall continue to perform contracts essential to its survival, but the committee may impose such restrictions as it may deem fit for future revival. The committee shall make suitable provisions for payment of tax or any other statutory dues. And Lordship also sees kindly 8. That is also contemplated, leave aside taking money from me, additional finance. If the committee decides that the enterprise requires financial resources to restructure or revive, it may draw up a plan for provision of such finance. Any additional finance should be matched by contribution by the promoters in appropriate proportion. And this should not be less than the proportionate. So additional finance is also contemplated. There's also provision for extension of timelines for completing this period. That is paragraph 7, when it is not possible to do it in 30 days. Now, this is the scheme. So, default is a precondition. Default here, default.
Unless the scheme will not apply.
So, default comes with an embargo, you can't recover. You have to follow this committee restructuring process. Then the committee comes to a conclusion after following the procedure.
After following A and B, then only go for C, recovery.
A notice given to me for making my representation. I will give it. They will consider maybe a TV study since it is within certain time span, and then they can take any decision. But just because it is SMA 2 and SMA 2 to NPA is a matter of time. There's no the secured creditor can't sit back and say very well, let me wait for another 30 days. It will become NPA and I will give 32 notice. They cannot do that. They can of course file a section 19 because that is nothing to do
with NPA.
With NPA. But even then, if the section 19 is also pending, the moment the default crosses 60 days, they have to follow this procedure. 19 may, what will be the consequence of 19? That's a different matter. Indirectly, that may stall the 19.
No. But the moment NPA is not the precondition for institution of 19.
Yes.
This scheme will not apply.
Scheme will not apply, but say during the pendency of 19, SMA 2 happens because NPA is not the option of the bank. NPA is 120 is 90 days.
No, but even if SMA 2 happens, then also 19 is
19 won't stop. So while the 19 is pending, they have to go for this corrective action plan. The corrective action plan may render.
They may. I tell you why they may. To declare an asset to be NPA, this scheme has to be followed according to you, right?
Well, may I correct myself? If you see 4.1, the moment it's SMA 2, this
scheme is attracted. Why? Because ultimate result is to declare it to be as NPA or not. Suppose take a situation. The bank thinks it fit. I will not declare you as an NPA. He has not carried out that process. He straightway go and invokes 19, proceeds and get a certificate.
Let me share my thought on this.
No, sir, one second.
Yes.
If he does not declare it to be NPA, question of invocation of SARFAESI does not arise?
No.
right? So he will not, the bank will not enforce the provision of SARFAESI. It will only proceed on 19.
Just academic, I am not. Kindly see 5C. Recovery, 19 is recovery. 19 is recovery.
5C.
What your lordship drew my attention to.
5C.
5C. Recovery will be only after 5 years the corrective.
5C.
Sorry, 5.3. 5.3C.
5.2.
5.3.
Huh.
First is rectification or restructuring. If these do not work, then recovery. 5C.
No.
I am not.
That is restricted for this scheme only. This scheme. This scheme.
Only.
This scheme.
SMA 2.
So if they don't.
Lordship is right. I agree. So if they don't,
if they don't proceed to declare your asset as NPA, they cannot take recourse to securitization straightway. Securitization out. They can proceed with 19, get a certificate, execute it by way of a recovery proceeding. Right?
But
the moment they have an intention to declare your asset as NPA, then according to you, they have to follow the entire scheme.
But there, I would like to make once more submission. Lordship kindly sees section. I mean, this paragraph. Kindly give me 1 minute. Paragraph 4.1. Once more.
Yes. Yes, sir.
So, where any lender on identifying an account as MSME account as SMA 2 or on receipt of an application from the stressed enterprise. So that 19 will subject 4.1. So on receipt of an application from a stressed enterprise also, this could be.
No. Question is, the moment you are an MSME,
I have a right to go under.
You have a protection or you have a ways and means under this scheme.
For restructuring.
But that does not debar 19.
This is not debar.
That's what I am on. 19 is a statutory remedy.
That is
unless it is specified that SMSE, whatever, are excluded, it doesn't exclude.
Absolutely right. But this certainly comes in the way of SMA 2 to NPA. Because SMA 2, the bank has to, no option, but it can happen earlier if the MSME approaches. But on identifying SMA 2, here I will show the identified SMA 2, the bank has to go for this.
I accept that they have identified SMA 2, unless she denies. I accept. The moment SMA 2, the scheme has to be followed.
The scheme has to be followed.
Absolutely.
And the scheme contemplates that first you try to.
Yes.
So see now, Balal,
I understand.
Now, apropos this, Balal, may I show our division-bench judgment in a suit in a matter like this? Balancing of equities is a question. Section 19, of course, the bank can go in the meantime, get its claim secured. 19, I think section 20, subsection 20 or so.
Let them proceed up to the stage of certificate. In 19, then the next question.
In the meantime, if they feel that they are that their dues are getting that the assets are getting depleted, then they can go under 19 subsection 18 and ask for interim order. Securing for attaching other assets. So they can secure themselves also in the process. So before the certificate. So the bank is not left.
None of us, neither you nor I, not the court rather, neither you nor the court is on the
rights of the bank
situation under 19. We are not on 19.
But the only thing I am saying here, because Lordship, that fell from my Lord initially, of course, on the first impression, for securing themselves, there is a forum available to them.
Maybe.
Under section 19,
yes,
19 subsection 18.
Statute provides for
that. Statute provides for that. So,
but I am not on that. I was asking you, I was telling you that to get an order of injunction without condition in the facts, in such facts, how far equity permits.
Yeah, that's a bit. Now, Lordship, may I start here before I come to the facts here? Is that the judgment of our division bench, our Chief Justice Chelu and Justice Banerjee and Justice Banerjee. They had also faced a situation like this without following the MSM. How did the court there chose to balance the equity? SR16s.
SR16, yes.
Lordship, kindly, this is very often cited. So, and this was also, since I happen to be there in the matter, I know that this was upheld by, not disturbed by Supreme Court in SLP. Kindly seize the order. Heard, it's a very short order. Heard counsel for the appellant bank. The entire dispute is with regard to declaration of the respondent unit as unviable. This NPA, unviable by the appellant bank. It is not in dispute. Credit facility was extended to the respondent unit by the appellant bank in terms of the scheme meant for MSME. Certain guidelines for rehabilitation of these units were also issued in order to promote the micro, small, and medium, small industry units. When an account becomes a non-performing asset, irrespective of whether it is a loan facility or credit facility given under the scheme meant for MSME or otherwise, the loan has to be recovered by the creditor bank. Basic. In order to promote micro, small, and medium enterprises, certain guidelines are made in order to see that if such entrepreneur has some financial difficulties, the procedure has to be followed, which guarantees rehabilitation of sick entrepreneur. Therefore, unless the borrower who borrows money under the above scheme is declared as unviable, the bank will not be able to proceed further. In other words, before proceeding with the recovery of the amount taking recourse to SARFAESI Act, the guidelines meant for rehabilitation of sick MSCs is required to be followed by the creditor bank. The question is, when SARFAESI proceedings under Section 13(2) of the Act was initiated, whether the guidelines for rehabilitation of sick MSCs was complied with by the creditor bank or not. Complaining non-compliance of guidelines, especially Clause 7B of the scheme, respondent debtor approached the civil court for a declaration that the unit ought not to have been declared as unviable without the approval of the next higher authority, that is the MSME committee, as contemplated in the above clause. This is the earlier scheme, MSME scheme, where there was an appeal provision also, but that's not there. Now, learned judge, after referring to provisions of the scheme, was of the opinion further opportunity must be given to the debtor plaintiff, providing right of appeal. Right of appeal is not there now, before all other opportunities for rehabilitation are closed. Therefore, learned judge directed the plaintiff to file an appeal as indicated in the scheme, and the scheme was dated to be filed within a particular time. Agreed by this concession extended to the creditor unit, or the appellant bank has approached this court, mainly contending that civil court ought not to have entertained the suit in the light of Section 34 of SARFAESI Act, where the jurisdiction of the civil court is barred, expressly barred. 34 of the SARFAESI Act reads as follows. 34 is quoted.
It was not a case of 34. I also have no hesitation in my mind that it is not a case of 34.
It's not a bar, but what your lordship put to me, I will not answer impromptu from my mother with that whether I can take this point in a Section 17 or not. That option may be there, but it will not exclude the civil court jurisdiction. The option may be there, may not. I will not say offhand, but that will not exclude, because if you are challenging the pre-NPA, now this is the NPA is bad. So that is, I could have come before 13(2) also. Had 13(2) not been impromptu issued, I could have come and said that you can't declare me NPA under without following the procedure.
Year 13-2 issued.
213-4 issued.
13-3A objection taken.
No. But then we had filed a scheme already. Here, what was done was we had filed a restructuring proposal to the bank before it became NPA. That is what I will show. In fact, that is in the opposition filed by them. In fact, their opposition has given. I will possibly not have to go into any disputed question of fact, because I will leave my petition aside, go by their opposition and show that I had submitted a restructuring proposal. They had asked me on my MSME registration details. I had given my MSME registration details. And then I had applied for restructuring proposal to
But
them.
perhaps they will not also deny that you are an MSME. Would you?
Today, we do not deny that they are an MSME. Lordship, what I will show is that, firstly, an impression has been cast upon your Lordship that there has been no corrective action plan at all followed by the bank, which is not the case. The record will speak.
That is not the case in the
volume about
opposition,
that.
not in the body of the opposition. At least.
Sir,
please.
yes. Then I'll.
Mr. Mitra.
If
Let us say.
I mean, since the question was asked to me, Lordship, otherwise I would not have. That is one aspect of it. Second, we had been. Sorry, I just slipped what the question of the court was. It just slipped my mind, Lordship. No, MSME, yes. So while this has been done, the proceedings were being done, there was nothing brought to the notice of the bank that we are an MSME having a certain right under an MSME circular. So please proceed accordingly. There are several restructuring proposals, considerations, and there are other notes which I'll place from the records which will show that this point was never raised, but still bank had given ample opportunity following that rehabilitation, restructuring, and then recovery part. That is what I will try and impress upon your Lordship. But today's date, yes, they are an MSME. That is on record.
Yes.
That's why I was surprised, because the opposition case, if I may just read one line, that is the.
It's a great satisfaction of the when they are arguing against a senior.
Please don't embarrass him.
Absolutely.
Not at all. Not at all. She's a very.
So
very
they have
competent.
they have to be put on courage.
That they have to be, but I had many matters against her. So she's not a raw junior. She's very competent lawyer. She's very competent.
I'm very grateful to my learned
Not
senior.
at all. In fact, I remember one matter where Joyanta Mitra and I were there. First time, he was leading me, and Justice Om Narayan Rai, we had not known him. His Lordship appeared for the bank. And after a couple of days hearing, we both said to each other, this man is so very good. And in fact, from then onwards, from that day onwards, whenever he would be there, I would be extra ready.
And I had the privilege of working with him for a very long, not very short period, but very closely because of the banking man.
Yes.
The opposition case is not that rehabilitation. The opposition, I will place it.
No, I will see.
At no point of time was it brought to the knowledge of the respondent bank that the petitioner number 1 was a MSME, or that there was any purported non-compliance. So their case is that I didn't know you are an MSME now, but the submission is now that I know you are an MSME, but then I followed the procedure and then it didn't work out. So but now may I come to the
division bench? Yes.
Now can I come to the last paragraph of this judgment? What did the court do? In that view of the matter, we are of the opinion, reading subclause 7B of the scheme, the provisions have changed, and section 34 of the Sarfazi Act. 34 has no application to the list raised before the learned single judge. In that view of the matter, we are of the opinion learned judge has taken care of the interest of both the parties, wherein the appellant bank is at liberty to consider consider the appeal and dispose of. Here it will be they are at liberty to follow the procedure. There it was. It is needless to say that clause 7B of the scheme is a mandate on the authority concerned, which is introduced only to see no arbitrariness is exercised on the part of the officials of the bank, in the absence of a proper exercise or compliance of the procedure contemplated in terms of guidelines for rehabilitation, the debtor unit may even be suffocated with the result of closing down the unit by arbitrary order. Therefore, unless the procedure contemplated under the guidelines for rehabilitation is complied with in accordance with the guideline, subsequent actions may lead to disaster. So, while passing the order, here also, but there was no embargo on them all this 1 year. Because this is as the Lordship has seen, this is a procedure at the most 45, 50 days. This would be over. 5 days notice, then 15 days, then 30 days. Say, let's take it as 2 months. But that's 45 of the RBI Act. That is a mandate on the bank. That if there's an MSME customer, you've got to follow that procedure. They can't say that I will not follow the procedure. I was seeing her response, I could make out this is, after hearing my lengthy argument, this is her response. But the opposition case, I will show it just the opposite. This is, I'm not required to follow it because I didn't know you're an MSME. But the document they've annexed, they have asked us to submit my MSME, particularly I have submitted it. And MSME department is handling this case. So, here the balancing of equities, there's no embargo on them in following that procedure and getting it done, like a bank guarantee injunction. If it is not in terms of if the invocation is invocation or not in terms, I get an injunction. But that does not mean that the bank guarantee beneficiary is remediless. I am getting an unconditional stay because tomorrow they can give a fresh notice in terms of the guarantee, and then the consequences will follow. So here also, if they have not followed the procedure, and the court has simpliciter says that you have not followed the procedure, so this course is bad. That will not prevent them, like a bank guarantee, giving us a 30 days notice is required. Notice and then following it. So that way, but I will also show otherwise that balancing of equities here can be very easily done or could have been done. There was no embargo on them in following the procedure. And even today, if they need the clarification, they can always get it from your Lordship. Unless they are allowed to argue a case contrary to their affidavit and say that we have followed the procedure. If at all they are allowed to argue, I will in advance cover that the procedure has nowhere been followed. The MSME committee word does not feature anywhere. Anywhere. Even we had our doubts by saying that you have not even constituted the MSME committee, which is a mandate. To which, of course, they have denied, saying that no, we have an MSME committee. But where is the reference? I will show my lord. Lordship now kindly comes to before I come to any other law, because this is also, Lordship can take it, Supreme Court, pro-NITS case. And lastly, Justice Dipankar Datta's judgment has said MSME guideline is mandatory. And the bank has to follow that.
No, that I have no doubt in my mind. About the mandatory character, it's no
follow it and then you recover. Like as the Lordship pointed out, the 5.3c. Do it, find that it is not restructurable, then you recover. But if the law requires like a 13.4, you have to give a notice first, get their response, however hard your case may be. You have to follow the procedure of law. You can't start with the sale notice. You have to follow that procedure. That is the mandate of the statute. May I continue, my Lord's officer? My Lord's, time is up. Not today, any other day, because today I have a matter fixed at 2 o'clock. When I was getting the calls. Except today and tomorrow. I'm saying tomorrow morning also I have a Friday if I can. Friday if I can.
Difficult to, not Friday is absolutely not possible.
Or tomorrow second half will be possible for me, but the first half I
don't believe in fixing time. Then it's very difficult.
Tomorrow second half possible.
Or you can give your reply afterwards. Letter complete is her opposition.
I have not yet placed my case. Not yet, because this is a factual matter. Because to follow the procedure, I have to just show what they have done, because that will be very incomplete. I've really done law.
What is your instruction? Would your client take a further call on the issue.
Lordship, this is a suit primarily.
Take it.
This is a suit. Lordship will look into the first relief. It is a suit for damages. There is a prayer for damages in this suit. So, and Lordship, may I place my submissions? Lordship, I'll show.
No, of
my
course I
thoughts
will.
yet.
Of course I will
Lordship,
hear you.
this possibly will not be the instruction of the bank. That there
Maybe.
is a claim of damages of 30 crores against me.
All right. Let me see the plain prayer once. Yes.
Lordship will find it also in the volume 2 of the application. with
No,
your
I got it. Page 12.
Page 12.
এই এটা একটু জল দিয়ে দিও তো পরে
First,
ভাত
the
দিয়ে দিও
fee damages. The guideline is what they're relying on to substantiate the illegal classification.
Guidelines?
To substantiate the case of illegal classification of NPA. They're relying on the guidelines for that, but the suit is primarily for damages and for
No.
and also
Prayer
for
B is there.
yes,
Prayer
prayer
B.
B for the declaration.
See.
Prayer A cannot be overlooked when it is.
No, it cannot be, but prayer B is the substantive.
B,
There it
D.
is.
If ultimately B is adjudicated in his favor, then only question of A comes.
And A can be otherwise also. So
Otherwise
there's
also. That's precisely.
Well,
It can be
I'm not
otherwise.
on my. This is not the aid of my damages claim.
BD sufficient. BD is sufficient to maintain the suit.
Yes, the maintainability.
But the thing is, Mr. Mitro,
Well, I can try, but
discontinuation
I can.
Lordship, today 3 p.m.
the discontinuation will be.
I understand, Lordship. May I continue at 2 o'clock because there'll be very little gap tomorrow. Tomorrow at 2 p.m. I know, no, Lordship, not fixing it.
No question of 2 p.m., 3 p.m., 3:40, 5:15. I will go by the list, sir.
I know. Lordship does.
Serially. No question of fixing any time. Unless the supplementary lists are published. That those are published, that some matters are missed, but interim order is expiring. That's right. Not for any other purpose. But for
Also
extension.
today as a new motion. This is to be heard as an urgent
That,
motion.
no, but that I have.
That is because of the baggage you are carrying.
The first 2 days list of mine, I have made that following the conventions. Monday, these Tuesday, Wednesday, Thursday chamber. But then I find it's impossible. I cannot maintain because there are matters which are like this. The interim order may expire. There are matters.
Many matters.
Many matters. So if I say that no, I will not take up today, it's a chamber matter, I will take up on Thursday.
But the
Interim
extension of
order will
interim
expire.
order is a matter of course when there is after hearing if the order has been
No,
made.
but how can I pass that order unless it is brought to the list? So that's the difficulty. Then I immediately omitted. After third day, I omitted those instructions. Every matter, every day, what will happen, will happen. Otherwise, very difficult. Ask your junior to proceed.
He will. He is more than competent. He's more competent. The way I like to place it, of course,
But
it is.
if I adjourn the matter, then very difficult. Because the later half of the list, they should also be given preference.
Friday, Lordship, gives on Friday.
Friday, I cannot. Kindly see
On
the
next
list.
Monday, Lordship. Next Monday, I'll
Even
continue.
yesterday, I have been assigned with other matters.
But Lordship will be taking us. So Monday, keep it the same position. I will finish it Monday.
No.
Monday, I'll
Difficult.
finish it, man.
Very difficult.
Monday, because it'll take me a couple of hours. It'll take me some more
I
judgments.
don't mind in hearing.
I know
both
that.
of
I
you.
know, Lordship.
It's a pleasure. It's a pleasure to hear all of you. All of you. But the time constraint is also a factor.
Monday, Lordship, can you keep it on Monday? The Friday, I know Lordship takes the other.
Friday, I cannot even
Monday, the Lordship, can keep it on
touch
Monday.
the original site.
Lordship
maybe.
memory, if you can remember section 2.0, which I also can't remember,
No,
but
no,
that's
no.
the
That's not the issue.
NPA, the
Very
Lordship will have no
difficult.
difficulty in recalling the.
If he can start at 2 o'clock,
I have a 2 o'clock fixed before a single bench, of course, and the 3 o'clock before the division bench. There's this fixed matter. So I may be able to come, I may be done by 2:30 and come, but I will not be able to argue to the full today. That's the whole difficulty, because then I shall keep myself free on Monday. So I shall ensure that I complete whole morning on Monday, and then I will, because it'll be done, and I will not. Lordship had heard our matter, that port trust matter, that escheats act over several days. But
those assigned matters have to be brought. I don't know when it will happen, what will happen.
Lordship is presiding over the heaviest determination of Calcutta.
Absolutely.
And your Lordships of the Calcutta High Court, the heaviest. And this is what original site is for, commercial litigation. This is the core of the original site. Core of the original.
The time constraint is the factor.
Lordship will have to live with. Lordship has
suit.
It's absurd for suit and
and not only that, there are matters suits are returnable under the heading to be mentioned for examination of witness. Orders are there.
It is absurd to have suit, and this is the heaviest bench of Calcutta High Court. Lordship has not yet started, but then Lordship filed first application in every commercial matter. But the other side, this should not be commercial. Why section 12A leave? That's the revocation of leave. So that's the first thing which will start off. Then that will be another.
Very difficult. That is the problem. The time constant is the problem. Otherwise, I don't mind, sir. I enjoy hearing all of you. But when and how?
Monday, Lordship keeps it Monday. I shall finish it. There's no fixed, Lordship. Unless Lordship
fix. Only today I fixed one matter because it was absolutely ended because of the time 4:30. I could not complete. So this morning. But that's take 10 minutes. They have taken and completed. Mr. Abhrojit Mitra, learned Ashut. Mr. Abhrojit Mitra, learned senior advocate, appearing for the plaintiff, has commenced his submissions. He shall, after proceeding substantially, he shall also proceed on the next day. He has proceeded after proceeding now, he has proceeded substantially and shall proceed on the next day. Once again. And shall complete his submission on the next day. Paragraph thereafter, M.S. Devlina Lahiri, learned counsel appearing for the defendant bank, shall commence and conclude her submissions. Full stop. The matter shall appear under the heading kishe ache?
New motion. So let it be new motion, my lord.
Motion.
Otherwise, it will not be.
New motion. কিছু উপায় নেই, কি করব? শুনতে শুরু করেছি, এখন তো ভেবে লাভ নেই। আরে এ তো অনেক সব মামলাতেই এরকম হয়ে আছে। Even there are matters who are
the last new motion, because then the other new motions can go.
No. Even there are matters which are directed to appear and had been appeared as, say, motion adjourned, but new motion, new chamber application for final disposal, everything is there. Because you will find the suit number and all the GA. So how to manage?
Because of a computer system.
How to manage? That's the difficulty.
Unlike that court, the suit will come with the baggage of GAs.
So that's why I omitted those instructions. At least the litigant should not suffer. কি বললাম? Matter shall appear on আজকে কত তারিখ? November 17, 2025, under the heading adjourn motion. তার কারণ আগের দুটো নিউ মোশন তো এই মামলার শেষ করে দিয়েছি, তো না আড্ডান দ্য হেডিং adjourn motion. এইটা না একটা ফাইলে রাখো। হ্যাঁ, এটা কিন্তু ইন রে GA1, ইন রে GA1। আগে যেগুলো অর্ডার করে দিয়েছি, না না ওগুলো তো ও নিয়ে গেছে অর্ডার। হ্যাঁ, এটা শুধু ইন রে GA1।
Monday, because Monday because that adjourn motion can be the first adjourn.
Sorry,
Can be the first adjourn motion.
whenever it will be appearing in the list.
Very well.
And on that day, it is understood if you are not, if you are stuck.
I'll start. But there's an interim order, Malad, which is due to expire this Friday.
To mention tomorrow, where?
In this matter.
In this matter?
Yes, ma'am.
Ashu.
Very limited extension I'm praying since Lordship.
Madam, matter has to be, interim order has to be extended.
That I
কি
understand.
বললাম? Since the interim order in the matter is expiring on
Friday 14th.
November 14, 2025, comma, the same shall stands extended till December 10, 2025, or until further order, whichever is earlier.
I'm obliged, deeply obliged.
Thank you. Yes.
It's my suit, my lord. My lord, I have instruction to withdraw the suit, my lord. Well, although, my lord, other two applications are appearing, my lord, as item number 40 and
You have
56.
received, you have got any interim order?
No, my lord, no interim order, my lord. Two appeals were preferred before the division bench. Today itself, my lord, we have withdrawn both appeals, my lord. I have instruction in writing from my client, my lord.
What happened to the appeal?
My lord, we have withdrawn both parties, my lord.
So bring the order of withdrawal of the appeal. I shall allow you to withdraw.
My lord, then your lordship will kindly keep all these three items together on Friday, my lord, for withdrawal, my lord.
Yes.
Under the heading for withdrawal, my lord.
Yes. Ashun. Which of the matters?
My lord, item number 7, item number 40, and my lord 56.
7, 40 and 56.
My lord.
Arising out of the same suit?
Same suit, my lord.
তিনটেকে একটা অর্ডার করে দাও তিনটেতে একটা অর্ডার মিস্টার Sachin, what's the name?
Tanmoy Roy.
Tanmoy Roy, learned advocate appearing for the plaintiff. Submits. তিনটেতে একটাই order. That these all the interlocutory applications in these three matters emanated from the single suit. Full stop. Paragraph. Learned advocate for the plaintiff has received instruction from his client in writing to withdraw the said civil suit. Full stop.
May I hand over the instruction?
The instruction dated, come on.
My lord,
এটা পরের দিন আনবেন ছেড়ে দাও
my lord, 9th November, my
Full
lord.
stop. The instruction is dated 9th November, November 9, 2025. Full stop. He has also submitted that the connected appeals preferred by
the plaintiff as well as by the defendant.
Parties to the suit.
My lord, he is for the
have also been withdrawn today.
Today, my lord.
Before the Honorable Division Bench. Full stop. Paragraph, Mr. Full name?
Rudrajit Sarkar.
Rudrajit Sarkar. Mr. Rudrajit Sarkar, take your seat. Take your seat. Mr. Rudrajit Sarkar, learned advocate, appears for the defendant. How many?
One. No, only sole
Defendant. Paragraph. In view of the above, all these three matters shall appear under the heading to be mentioned. কেন? For withdrawal, or for settlement, no, to be mentioned.
A small prayer, if it can be kept on next Monday or Tuesday, because there is a technical difficulty. The original advocate on record for the defendant was one Mr. S.K. Bajoria. One Mr. Bajoria. For some reason, the clients are not in good terms with him, so he has also not given change. The new advocate on record is Mr. Devanshu Rita.
How does it matter?
If
He shall withdraw. Nothing.
Because I need a leave to file a fresh wakalatnama because a sum of rupees 1 crore 25 lakhs is with the registrar, which under the settlement is to return back to the defendant.
So then a long run process. Let him withdraw, then you take care of your own problem.
No,
it's a long run process.
Well, lordship can record my no objection or my consent, my lord, with regard to withdrawal of that money lying with the learned registrar.
So on the next day?
My lord.
So accordingly, these three matters shall appear under the heading to be mentioned, one after another, on
Monday or Tuesday, your lordship.
On next Monday, 17th. November 17, 2025.
Grateful.
Chalo, next.
The Roman Catholic.
My lord, I am for the defendant petitioner in this matter, my lord. My lord, I am being led by Mr. Moinak Bosch in the matter, my lord. Kindly a short pass.
Sorry?
My lord, I am the defendant petitioner, my lord. My lord, I am being led.
What is the petition for?
My lord, it's an application under order 40. Order 14.2, my lord. My lord, to decide the suit on preliminary issues, my lord. To decide the suit on preliminary issues, my lord. To frame preliminary issues and decide the suit, my lord. And it's an application under order 14, my lord.
All right. Who is appearing for the plaintiff?
Yes, my lord. Mr. Sanjay Kumar Baid is the advocate on record, my lord.
তার লিখুন আসুন। MS, this is an application taken out by defendant, sole defendant.
Yes, my lord. Sole
Huh?
defendant. Sole defendant.
Take your breath. Take your breath. I will simply dispose of the application that the issue can be tried at first.
A short,
the time.
my lord, a short pass over, my lord. Mr.
No.
Boses appeared.
No,
my
no,
lord,
no.
beating me, my
কি
lord.
বললাম? Taken out by the, I'm passing order in your favor. Taken out by the defendant. Inter alia praying for framing an issue with regard to inter alia praying for trying the issue of maintainability of the suit as the preliminary issue. Paragraph.
বলেছি।
Mr. Saurath Dutt, DUTT, learned counsel appears for the plaintiff. First paragraph. In view of the above and considering the prayers in the application, the issue raised by the defendant with regard to the maintainability of the suit shall be decided as the first issue at the time of trial of the suit. Full stop. Paragraph. Accordingly, comma, this application bold GA.com number 4 of 2025 stands disposed of, comma, without any order as to costs. The bold করবে GA.com নম্বরটা. Next.
Item number 9. My lord, I appear for the plaintiff. I appear for the plaintiff, my lord.
Next.
I appear for the plaintiff, my lord. This is an application that has been taken out by the defendants saying that this suit, my lord, is a non-commercial suit. Well, this was perhaps taken out at that point of time, my lord. There was a dispute as to whether an action under section 106 of the Transfer of Property Act
Was not.
Was
Thereafter the decision came that the notice is commercial. It can be tried.
Yes, my lord.
The test is whether the premises is used as commercial.
Admittedly, here commercial purposes is admitted. The only point was whether a 106 action was maintainable before this honorable court.
Who is for the defendant?
Ms. Somali Mukhopadhyay was appearing. Her clerk is requesting for a short pass over.
Show me the division bench judgment. Ask him to ring the learned advocate that the matter has been taken up.
Kindly see the answers at para 122.
At
para 122 are the answers, my lord, or are the queries are answered by the honorable division bench. The questions are also quoted. Page 85 of the judgment, my lord. Page 85. Page 85. Towards the end. May I please, ma'am?
Once.
Ma'am. Question C, my lord, the answer to question C.
Let me
I am sorry.
get the advantage of once more reading.
Sorry.
In the meantime, let the advocate come, learned advocate.
What I have been told is they intend to withdraw this.
Wait. Show me the relevant pleading in the application. Why ground for rejection?
Yes. My lord, may I just give my lord a small background before the pleading? Just one
Not
background.
required, sir. You show me the paragraph that where he has pleaded his case for rejection. Show me.
I will kindly take the affidavit in support of the master summons. For their case, my lord, will kindly take para 4 onwards. Para 4, 5, and 6. Really, para 5 is their legal argument. Para 5 is their legal argument.
5
is the legal argument. But my lord, what I was trying to indicate is para 4. Here we had initially filed it in the non-commercial division.
Paragraph. Ashun.
Yes.
This is an application taken out by
the defendant. Sole defendant.
By the defendant. না তার আগে লিখুন Mr.
Shaunak Mukhopadhyay.
Shaunak Mukhopadhyay, Learned Advocate Counsel, appears for the petitioner.
For the plaintiff.
I'm so sorry. Thank you. For the plaintiff opposing this application. Paragraph. None appears for the defendant applicant, stroke applicant. Paragraph. This is an application filed by the defendant with a prayer for rejection of the plaint and consequently dismissal of the suit. Full stop. The grounds, paragraph, the grounds in support of such claim stated in the supporting affidavit to the master summons are quoted below. 456. Quote 4 to 6. 456. আচ্ছা 3 থেকেই কোট করে দাও E26 কোট 1 post paragraph the issue raised for claiming rejection of plaint
So the
has been
petitioner, my lord, in this matter, my lord, defendant. Well, when we have filed this suit, this application, my lord, there that time, my lord, there were judgments.
so now the issue is settled.
It is
I'm dismissing
But-
your application.
My lord, there are other points we have taken in the written statement regarding the jurisdiction of
Sir,
the.
I am not, madam, I am not commenting on anything or else.
No, regarding the
Only-
jurisdiction of the
It will be tried.
commercial court. Yes,
It will
well,
be
that,
tried.
that issue kept maybe.
Yes, it will be tried. Don't worry. You take your breath. Take your breath. Sit down. Sit down. Take your breath. What's your name?
Somali Mukhopadhyay, my lord.
Somali Mukhopadhyay.
Yes, ma'am.
Take your breath. লিখে দাও MS Somali Mukhopadhyay, learned advocate, appears for the defendant oblique applicant. ঠিক আছে, এবার কি লিখেছি? Don't worry. On the above ground has already been decided by the Honorable Division Bench in a reference by its judgment in the matter of by a judgment dated June 18, 2025 in the matter of in the আমি যেরকম ভাবে লিখি in the matter of versus versus there is no reference number.
No, my lord, there seems to be, because the suit, my lord, there was a contrary opinion formed by the learned coordinate bench. There are two contrary opinions of the coordinate.
Reference number, what is the proceeding registered? How the proceeding was registered
It's an
before the division
unreported
bench?
judgment thus far. The CS number can be noted, my lord, the CS com number.
কি বললাম? rendered in এইভাবে লিখে দাও IA নাম্বার এত CS নাম্বার এত পুরোটা দেখে দেখে লেখো হলো ফুল স্টপ wherein it has been held that a suit for eviction in connection with a lease pursuant to a notice issued under section 106 of the Transfer of Property Act 1882 if is otherwise characterized as a commercial suit within the meaning and scope of the Commercial Court Act 2015, comma, the suit is a commercial suit. The suit is to be classified as a commercial suit. পড়ো কি লিখলাম পড়ো এটা rejection of the off plaint such and such was rendered in such and such rendering হয় না rendered such and such comma দিয়ে if otherwise is characterized commercial suit within the meaning and scope of comma and shall be maintained as such. Full stop. I'm keeping this.
My lord, the judgment reported in 2025 SCC Calcutta 5076. This judgment, this reference judgment.
আচ্ছা কি বললাম ওই rendered in such and such reported at
2025
2025 SCC online bracket cal bracket close
5076.
5076 5076 দাঁড়াও আমিও লিখে রাখি 2025 SCC online cal 5076 এই দেখো এইভাবে লিখবে আর আমি যেরকম লিখি ইটালিক্স বোল্ড paragraph. However, it is made clear that the other defense and issues.
But we have taken the defense of jurisdiction as well.
That's right. The other defense
jurisdiction of commercial court only.
Right. However, it is made clear that same as above, all other points taken by the defendant in its written statement shall be tried in accordance with law at the time of hearing of the suit, and this court has expressed no opinion on the same.
One
paragraph. Accordingly, this application GACOM IAGACOM 5 of 2024 stands dismissed, without any order as to cost. Thank you.
My lord, one direction, may I humbly beseech, my lord. My lord, the suit is otherwise ready, my lord. If, my lord, discovery and inspection can be issued, an order for discovery and inspection can
Sir,
be
this is a different application.
Yes, my lord, but suit is also on board. If I may only request, my lord, only an order for discovery and inspection, nothing more. Discovery and inspection. No, inspection.
On the prayer of the learned counsel for the plaintiff, the hearing of the suit is expedited by directing the parties to complete the cross order and discovery
And file
within 8 weeks from date.
File an affidavit of admission and denial as per the Commercial Courts Act.
In accordance with law, and to comply with all other formalities according to the required to be complied for a commercial suit in accordance with law.
Deeply obliged.
10 weeks করে দাও. So, next.
Number 10.
Yes.
Your Lordship, I appear on behalf of the plaintiff. Your Lordship, I've been informed that the parties are discussing to settle the matter. Your Lordship, kindly grant an adjournment for 20 days. Your Lordships, item number 10, 11, 31 and 32.
11?
10, 11, 31 and 32.
30 and 31.
I stand corrected, Your Lordship.
10, 11, 30 and 31.
30 and 31.
Separate applications.
10, 11,
30 and 31.
30.
30 and 31.
10, 11, 30
and 31.
10, 11, 30 and 31. একটাই অর্ডার করবে সবকটা নাম্বার দিয়ে একটাই অর্ডার MS
Rupal Singh. Messrs. Khaitan.
Your name?
Rupal Singh. Your Lordship. Rupal Singh.
Rupal
Singh.
Singh. Spell out.
RUPALSINGH.
MS Rupal Singh, learned advocate, appears for the plaintiff. Paragraph. Mr. Pranit Kumar Wagh, learned counsel, appears for
The defendant number 1.
What about the other defendant? Defendant number 1. MS Orunima Lala, learned counsel, appears for defendant number 2 and 3. Anybody else? How many defendants?
5 defendants.
What about the others? Full stop. The rest of the defendants are not represented. Paragraph. The parties, any interim order passed?
Yes, Your Lordship.
There's an application which is pending for restoring the interim order that's pending.
Passed and vacated.
No, Your Lordship. That thereafter, thereafter, in an order, there was some protection which is related. The interim order was granted till the disposal of the application. So it has not been vacated per se, but Your Lordship, the application is still pending for extension.
Parties jointly submit. Parties present today jointly submit that the parties have taken steps for settling the dispute amongst themselves, and as such, there is a possibility of settlement in the suit. Paragraph. The parties have also submitted that initially an interim order was passed, which was vacated.
Vacated means time lapse, so it automatically vacated.
That's right, which had expired with the passage of time, which had expired by efflux of time. However, subsequently, some protective order had again been imposed,
Yes, sir.
which is subsisting. Full stop. Paragraph. Be that as it may, comma, since all the defendants are not before this court today, the parties shall be at liberty, parties shall serve notice upon the non-appearing defendants and file an affidavit of service when the matter shall be taken up next. Paragraph. In the event, comma, the settlement fructified, comma, parties to the suit shall draw the necessary terms of settlement and sign the same strictly in accordance with law and execute the same, sign and execute the same strictly in accordance with law, which shall be taken on record at if the suit ultimately is settled. Chalo. এই একসঙ্গে এই চারটে ম্যাটারে, হ্যাঁ, the matters shall appear under in the list, and the matters shall appear under the heading for settlement. কি বললাম? For settlement. Tell me when.
After 20 days, January.
For settlement on on December 19, 2025. Paragraph. Affidavit of service filed by MS Lala. How does it matter? Come, keep it with you. দরকার নেই, যদি কন্টেস্ট হয় তখন দেখা যাবে।
Very deeply.
Next.
The moment I knew, Milord, the previous matters 10 and 11, it's going to get settled, Milord, I came with a smile. Now, this matter, Milord, but item 10 and 11, when I came to know that there's talks of settlement, Milord, I came with a smile. So this matter I'm appearing, Milord, this is a, Milord, a point which I will urge before your Lordship. Written statement, leave granted. And for the defendant in the matter, Milord, item 12.
12.
Milord, leave granted by the Honorable Court on 6th of August 2025.
My Lord, I am for respondent in this matter, my Lord. My instruction is that, my Lord.
My Lord, 6th August 2025. It was the 119th day, my Lord. On that day, leave was granted by the Honorable Court with the endorsement to submit the written statement in the department in the course of this day, subject to acceptance by this court. We had done that, my Lord. We had complied with it.
Where is the application?
Here lies, my Lord, the issue. We had filed an application, my Lord, on that day. Later on that day.
No, come up. Yes.
My Lord, this application, when it was, my Lord, last taken by your Lordship, my Lord, on 3rd of November, my Lord, the matter was taken up by your Lordship. A query fell from your Lordship that why is the application now required? It's not required once the leave has been granted by the court. And
no, I have never said that why the application is required. Certainly not. On the contrary, I have a contrary view.
I know the view. My lord.
Unless the
Unless
application
the
is allowed,
application is allowed. Now,
the
my lord,
written
today
statement
my
My
will
lord,
not be
I'm
taken.
seeking
may I
2
humbly
weeks
submit this?
time to file my opposition
Next,
Opposition to
to in GA2.
next.
my only I know. They have, my lord, they have taken out an application which is GA3 for
Show me
judgment
the
upon
date
admission.
of the application when you have taken out the master summons.
My lord, may I file a list of dates that we have prepared?
Show me the master summons, Degi.
Yes, Master Summons.
Original.
It was filed on 19th of August 2025.
1 second, wait.
My lord, along with the Master Summons. GA2, hai na? Just show me GA2. Yeah. Correct.
19th August.
19th August, and this was served on them, my lord, on 20th of August.
When the leave granted
The
to file
leave was
written statement?
granted, my lord, on 6th of August 2025, endorsed on the written statement by
Show
the
me,
Honorable Court.
yes, show me that it is maintainable.
I will. That's my endeavor. My lord, today, Lord, may I only submit this? I'll leave it to your lordship thereafter. This is what I was thinking, because my lord, today, if there's no application before the Honorable Court, because my lord, when it was being taken up by the Honorable Court previously, my lord, whether even if, my lord, there's no application, because there was no application then, the Honorable Court was of the view that if a leave is granted by the Honorable Court, then filing of an application may not be necessary. Because
Who
today,
said?
Lord,
I have not said.
Not your lordship.
That's right.
Not your lordship.
That's right.
Lord, I need to make this clear, because Lord, today there's a in this matter, Lord, what we are facing is, Lord, written statement has been, because it was the 119th day on 6th of August, Lord. So we had to take the leave of the court. The court had, my lord, then asked that why the leave is to be granted, because unless and until we explain, my lord, the delay, this leave would not have been granted. We did that, my lord. Orally, we
Show me
indicated that.
this is permitted in law.
Lord, kindly hear me out. My lord, may I only take 2 minutes of your lordship's time. The leave once being granted, my lord, today what is the fate? I ask this question to myself because this is what will fall for consideration by your lordship. My lord, today if a leave is granted to file a written statement, and it is filed in accordance with the leave granted by the Honorable Court, without there being an application on board on that particular day, my lord, because on record I find that, my lord, 19th of August 2025 is when GA2, which is the application which will come up for, my lord, consideration by your lordship, that was filed after, my lord, the 120th day, seeking to explain, my lord, the delay in filing the written statement. That's 19th of August 2025. We have filed that. But prior to filing of this, my lord, on 6th of August, the leave is granted by the Honorable Court. Today, the fate of the written statement, who are the fact, my lord, that they have filed an application for judgment upon admission, that's GA3, which is on board. In paragraph 12 of this application, my lord, they have extensively relied on the written statement.
So what?
So today, my lord, if this application also records this, I'm more on the leave granted by the Honorable Court, really, my lord. Because today, if the Honorable Court has granted a leave and there's no application on board by, my lord, the party,
What shall be the consequence?
I'm very grateful, my lord. That's what I'll try and canvass my submissions on. Subject to consideration by your lordship, my lord. I may be wrong, but this is what I was, my lord, contemplating, because I, my lord, was at a loss to understand that, my lord, if there is no application today, and if the Honorable Court has granted a leave to file the written statement, subject to a condition that it has to be filed on that day before the department, which we have done. My lord, the leave has then been acted upon by the party on the 119th day. My lord, oral hearing before the leave was granted, my lord, to the extent of explaining the delay, which has been done. My lord, in my very respectful submission, it was an application which was an oral application, because it was moved to explain the delay, which caused the Honorable Court to grant the leave. And the leave has been endorsed. That would, my lord, tantamount to an order of the court that this leave is being granted to file the WS within the 120 days mandate, which has been acted upon, my lord. Now, we have filed an application on the 19th of August 2025, which is pending adjudication.
So if your submission is accepted, then Why you have filed an application?
I'm very grateful. It was by
One.
abundant caution.
Two.
And also, my lord,
Two. If your submission is accepted, then 119th day written statement will be filed with the leave of the court, and the application might come after 300 days. No issues.
that will be misconceived, perhaps not. If it's an application, I'll answer that question, my lord. If that's not what's falling from your lordship, that today, after having this file on 19th of August 2025, seeking to explain, my lord, the delay, which is beyond 119 days, my lord, subject to being corrected, because, my lord, I'm only trying to canvass my submission. Kindly don't take me amiss, because I'm trying to figure out, my lord, this is something which I have my doubts on. My lord, I'm trying to argue only to this extent that the law prescribes a mandate of 120 days. I have to file the written statement within 120 days.
It's your choice.
It's my choice.
Not you have to.
No, I can't get a chance beyond 120 days.
That's
the law.
right. That's
My lord,
right.
I have my chance of filing, not filing till the 109 to 128th day. The moment that day, that threshold crosses, my chance is gone.
No. Beforehand, you have to explain 30 days. Delay of 30 beyond 30 days.
Beyond 30 days, the entire 60-day period I have to explain.
That's right.
In fact, the 90-day period.
That's right.
That I have to explain.
31st day to 120 day, 20th day you have to explain.
My lord, here, when we that explanation and, my lord, also acceptance by the court subject to conditions, which, my lord, is the cost part. That if I do not do it, if the honorable
Cost
court
part
feels,
is, I have already held in my judgment.
my lord,
Cost part is a penalty given
my lord,
to adopt a curative measure provided under Order 8, amended Order 8.
my lord,
That you can file beyond 30 days by paying cost
lordship,
upon showing sufficient cause,
my lord,
but not beyond 120 days.
indeed.
So an application has to be there showing your reasons and causes, which has to be, which you have a time till 19th day to file, but not beyond 120 days.
120 day beyond, my lord, my chance is over. That's the death knell. After that, my lord, even if I want to, I can't. That's, my lord, the distinction now I'm trying to draw before your lordship is this. The GA, the application, my lord, would be necessitated to explain the delay in filing that written statement, because the wording is, my lord, that sufficient cause has to be shown. And then the honorable court has the, my lord, the prerogative to, my lord, impose conditions, which would include costs and other conditions, my lord, that unless and until this is done, your written statement I will not accept. That's always there. The distinction now I'm trying to draw is this. If, my lord, that explanation is given in the written statement itself, in paragraphs in the written statement, and it is explained as to why the delay has occurred, I ask this question to myself, my lord, then will...
So has the CPC been amended with regard to the format of the written statement?
No, indeed not, my lord. Indeed not. But with this, my lord,
written
explanation
statement
part,
is specified. Written statement is
Only the
specified
periods.
under Order 8.
My lord,
How it will be drafted, what should be the content.
lordship. But in this, my lord, proceeding, the explanation has also been added in the written statement.
That's neither here nor there.
Indicate why. I'll indicate why. But because when the leave was being prayed for, it was being argued from the written statement, because there was no GA before the court. There was no separate application on that day before the court. That was the 119th day. So, my lord, today, on that day, I'm, my lord, traveling back to 6th of August 2025 when this was argued. My lord, this, the explanation in paragraph 13, 14, 15 of, my lord, the written statement after, my lord, the dealings.
So you are asking the court to take the written statement equally as an application for condonation of delay.
Perhaps no, my lord. No.
Then
I am praying that, my lord, this explanation has been given. So, my lord, all that a party subject to being corrected, my lord, is required to do is to explain the delay.
Correct. Within 120th.
Within 120th day, which we have done, because 119 the leave is granted. So the court
no, you have to explain in the application.
No, that's the question, my lord. The query that's falling from the honorable court is
whether a separate application is at all absolutely necessary, even if the explanation has been given in the written statement. That will fall for confusion
How
by
the
your lordship.
written statement will be taken on board unless the explanations are shown to the court?
Very grateful. My case is this, that the explanation has been shown to the court. And that's because of the
On the
pleadings
basis
there.
of how you have shown this to court?
Kindly take up the written statement once.
So you have shown the written statement to the court. So the written statement which is not on the board, court will take cognizance of that, and after being satisfied, whatever pleading is there, court will grant you leave.
May I only indicate this? I may be, my lord, absolutely wrong. I'm only praying for, my lord, indulgence of 2 minutes, my lord.
No, I don't mind, sir. You can take
Only
as
because
much as
I'm
minutes.
a little confused, my lord. I'm trying to, my lord, argue against myself perhaps, but this is what I am trying to place before your lordship. My lord, the reasons here, not all the written statements are the same, my lord. In most of the written statements, we don't give these, my lord, the explanations in the written statement. It's not given. This written statement I find has, my lord, the explanations which were placed
So
before
according to you, this is a written statement which is a classical one.
No, my lord. According to me, this is a written statement which has the explanations for the delay, which has, my lord, occurred in filing the written statement, not filing it within 30 days.
So you show me the law that an application or a written statement, whatever nomenclature you call, if it is not taken on the board in accordance with law, whatever pleading is made therein, court will take cognizance and pass an order.
My lord, kindly take up, my lord, order 8 once. Order 8, rule 1. I may be absolutely wrong, my lord. I'm only trying to canvass this submission because this is something which is really bothering me, my lord. Kindly take up order 8, rule 1, my lord. Kindly see the language. The defendant shall within 30 days from the date, order 8, rule 1, my lord, 30 days from the date of service of summons on him, present a written statement of his defense, present, provided that where the defendant fails to file the written statement within the said period of 30 days, which is the case here also, he shall be allowed to file the same on such other day as may be specified by the court for reasons to be recorded in writing, but which shall not be later than 90 days from the date of service of summons. I pause here for a moment, my lord. The law, in my very respectful submission, does not mandate filing of an application, my lord. Kindly bear with me. Kindly see what it's, my lord, what is prescribed by the law. He shall be allowed to file the same on such other day, that's the court's, my lord, prerogative, as may be specified by the court. Again, the court's prerogative, my lord, has to be within 120 days after the amendment. For reasons to be recorded in writing, the court's prerogative, my lord.
Where the reasons will be recorded?
In the order. That's what, my lord, I...
Show me the order.
My lord, or the leave granted by the court.
No.
Here the leave has been granted, my lord.
Leave granted, subject to? What is the language of the leave? Show me.
Subject to acceptance by this court. Subject to acceptance by the court. That's the language used, my lord. Kindly see, my lord, this is at the endorsed.
Original written statement ta kothay?
It was, my lord, on the last occasion, your lordship had directed this written statement be brought.
Hey, I mean, বলেছিলাম written statement be brought.
I was there.
My learned junior had appeared, so
I was there, my lord. It fallen from your lordship that the written statement should be brought from the department. It was directed to the order. It is there on YouTube as well, my lord.
I passed one order, I remember.
And then in the second application, when I was about to move.
No, not in this matter.
I am only troubled because of this language, my lord. That is why I wanted to make this submission before your lordship. Kindly see, does not mandate, my lord, a separate application. Kindly see, it says, for reasons to be recorded in writing, but which shall not be later than 90 days from the...
So where the court shall record its reason?
That is where, my lord, may I only pray for this? This, for reasons to be recorded in writing, my lord, is the discretion of the honorable court. If the court so seeks, the court may record a separate order by which, my lord, the written statement is taken on board by the court in the order explaining, my lord, giving the reasons. Number one. Number two, my lord, secondly, the court may, while granting the leave, because that's not specified in the law, the court may, while granting the leave, my lord, record there if any specific reason is to be recorded by the honorable court. It is discretion of the honorable court. Since it has fallen from your lordship, a separate application is mandated. I am trying to make a submission that it is not mandated by law. May I try and read this again, my lord? I'm trying, my lord. Lord, may I pray for this indulgence? Kindly permit me to come back next week. I'll do some more research on this. I'll try and satisfy your lordship. Or maybe, my lord, I may not be able to, but I'll try and, my lord, first be very clear about this. By then, my lord, the written statement, the original written statement will be before the honorable court. This part is what is bothering me, my lord. I'll try and read up more. I'll come back. Kindly keep it next week, maybe Monday, Tuesday, my lord, and permit me to come back on this. This is a gray area which needs clarification, my lord. Whether an application is at all required, where is it in law that it is required, my lord?
Otherwise, where the court will record
Indeed,
its reason.
indeed. Where will it record? That is, my lord, to my understanding, very limited understanding. Perhaps it would be in an order separately or in the leave granted discretion.
Order will be on what?
It will be on application. It has to be on application.
That is what I'm arguing.
Yes.
Sir, I'm trying to argue that an application is not required. Kindly analyze this more and come back.
No, kindly see this application. What is the prayer?
No, I'll withdraw
What
this
is
application.
No extension is sought. No explanation is given. Nothing.
No, what is this application?
He has filed the GA. This is which is heard by your lordship today. Your lordship is hearing in a GA, my lord, filed by him.
I'm trying to argue that GA is not required.
Yes.
You were not here, so you do not know what has been discussed.
I was hearing on the online.
Yes. So the point is, Mr. Tiwari,
My lord.
he is saying that no application is required at all.
No, I don't agree with that.
You may not agree, sir.
Yes.
But you have to argue, showing the law. Your mere disagreement or my disagreement will not matter, or his agreement does not matter.
My disagreement depends upon the Supreme Court judgment.
Huh?
My disagreement is depending upon the Supreme Court judgment.
Absolutely, you are welcome. You are welcome. Ashun. The master summons has been taken out. Inter alia, please listen. Inter alia praying for extension of time.
But there is no prayer. Kindly excuse me, my lord. There is no prayer. He is taking leave of the court. No extension is sought for. Seeking my lord's leave to file it.
Inter alia praying for leave to file written statement.
Someone.
As the same is being filed within the statutory mandate of 120 days. Poster. Paragraph. The relevant dates are: writ of summons was served on the defendant on
9th April.
9th of April 2025. 9th April 2025.
April 9, 2025. Bold korbe date gulo. Full stop. The defendant mentioned the matter before the coordinate bench on
August 6, 2025.
August 6, 2025, comma, when? The coordinate bench granted leave to file the written statement. And the written statement was filed on
the same day.
August 6, 2025. Full stop. Admittedly, there was no application in writing on the board on that day seeking an extension of time to file written statement beyond 30 days, but within 120 days from the date of service of writ of summons. When you have filed a written statement date?
My lord, August 6, 2025.
August 6, 2025 was the
19th day.
19th day. 119th day. Board. Mr. Paragraph. Mr. Pronit Bagh, Learned Counsel appearing for the defendant submits that the amended provision of Order 8 Rule 1 does not provide for any mandate that an application has to be writing and filed before this court, seeking extension of time to file written statement beyond 30 days mandate. He submits that once the leave has been granted by the court within 120th day, comma, it is sufficient extension of time for filing the written statement beyond 30 days mandate. That's your submission? Paragraph. Mr. Moti Tiwari, learned advocate appearing for the plaintiff, has denied and disputed the submissions of Mr. Bagh. Full stop. Paragraph. The parties jointly pray for an adjournment of hearing on the issue as it will be a contested hearing, and the parties and the respective counsel shall come prepared on the next day. Paragraph. Accordingly, the matter shall appear. Paragraph. On the next day, the original suit record, including the record of the office of the sheriff and the report from its office, shall be filed before this court, shall be placed before this court for conclusive hearing on the issue. For a conclusive hearing on the issue. Paragraph. The matter shall appear, the application shall appear under the heading kishe ache?
New chamber.
New chamber. On.
It will be on 28th of December. It's a Friday, my lord. 28th of November, my lord.
28th?
15 days from now. 16 days from now.
Friday, I will not take up.
Then 27th, my lord.
Thursday suit. Very well. 27th, November 27, 2025. I'm ready with the Xerox judgment.
My lord, I'm grateful to you.
Whatever judgments you want to place, bring those Xerox copies.
I'm so obliged.
And you also bring whatever you want to place.
I'm very deeply obliged.
Hey, এটা দিয়ে দাও, এটা রেকর্ডে রেখে দাও list. Bring another list of dates on the next day also. ঢুকিয়ে রেখে দাও। আর এই অর্ডারটা তো দিলাম, সেই মতো ডিপার্টমেন্ট থেকে পুরো সুটের রেকর্ড, শেরিফের রেকর্ড আনিয়ে নাও। Yes.
I am appearing for the particular
ये हाँ मतलब होते हैं 15 के कौन some confusion, two sets of defendants having applications for extension of time to file their written statement. Bolo 13 तक
But my lord, the third set of defendant had also filed a similar application. And my lord, in that, my lord has passed an order, which is of 6th of November 2025, last week only, my lord. And my lord, when I see the affidavits, which is of the first set of defendant already allowed with cost, and the two affidavits which has been filed now, my lord, the reasons for delay are almost identical, subject to correction.
No, not almost identical, but yes, some parts are similar. But look, their days are different.
Days are different. Yes, my lord.
These are different.
But in the
This is that matter.
yes, same suit.
Different set of defendants this time. I am appearing in item number 4, 21 to 25. I've got the
for
list of dates.
16 for 16 to 18, which is IAGF 4 of 2025.
Yours is
That time, yes.
So which one is this? All applications are appear in this same item.
Yes.
Well, that's J4 and
13
J5.
and 14.
13 is J4 and 14 is J5.
I'm in GA5.
So let me take up 13 first.
On any may I hand over the short list of dates for those relevant dates which your lordship is. हाँ 20 different number 16. The plaint was presented on 9th of June, 18th of August. Writ of summons was served upon us.
Wait. আসুন প্রথমে 13 order করো. This is an application filed by the defendant numbers
16 to 18. 16 to 18.
16 to
17, 18.
16 to 20.
18.
16 TO2 18. In the pending commercial suit, praying for extension of time, comma, beyond 30 days, but within 120 days from service of writ of summons, comma, to file the written statement. First up. Paragraph. The master summon has been taken out on
10th of November 2020.
November 10, 2025. Date bold হবে হ্যাঁ date গুলো bold. Which is 100 and
No, this is 10th of November, na?
54 days.
I am seeking condonation of 54 days of delay, so this would be 84th day. No, 84th day. 84th day.
84th day from the date of service of writ of summons. Full stop. Full stop. Paragraph. The plaint was presented on
19th
June 19, 2025. August 18, 2025, a date gulo bold hobe baba. The writ of summon with a copy to the plaint appended thereto was served upon the defendants. Defendant number
16 to 18.
16 to 18. First up. When 30 days expired?
30 days will expired on 17th of September 2025.
On September, date gulo bold hobe kintu. On September 17, 2025, the 30 days mandated under the amendment to bold order 8 rule 1 the bold have of the code of civil procedure 1908 within brackets CPC এই অবধি bold হবে italics bold italics হ্যাঁ এই যে দেখো তুমি দেখো না বুঝতে পারবে এই হবে ঠিক আছে কি বললাম under the amended provision করে দাও amendment না করে under the amended provision of such and such expired from the service of writ of summons when written statement was affirmed.
But written statement was affirmed on 10th of on the same day.
Yes, yes, yes.
10th of November 2025. It is annexed.
November 10, 2024, the written statement was affirmed.
25.
25. So there is a mistake in paragraph 5 of the judgment. Has to be corrected.
Order copy to the
Of the other one.
oh, you judgment copy.
Judgment for 24, that will be 25.
It should be 25. কি ছেপেছে বুঝবো কি করে SB Ghosh MG কি বললাম নভেম্বর was affirmed on behalf of the defendant number
16 to 18.
16 to 18. Full stop. And when 120 days will expire?
On 18th of December 2025, it will expire on that.
On December 18, 2025, the mandate of 120 days under the amended provision of Order 8 will expire. Order 8 of CPC, Order 8 Rule 1 of CPC will expire. Full stop. Paragraph. In the same suit, the defendant numbers 5 to 12 and 15 had previously took out an application.
But I think it is entirely 5 to 15.
5 to 15 entirely, not 5
All
to
of
12
that
and
together.
15.
Mr. Ghosh moved it 5 to 12.
5 to 15.
5 to 15.
All of
ও দুটো আলাদা ছিল ডেটটা আলাদা ছিল 5 to 15 কি বললাম being IAGA com fee of 2025 poster upon being satisfied with the explanations shown in the application, This court, by its judgment dated November 6, 2025, has allowed the written statement to be taken on record. Has been allowed the written statement, has been allowed to, dated such and such, allowed the written statement to be taken on record.
Payment of cost.
Upon payment of cost as directed therein. Paragraph. On perusal of the averments made in the instant application, it appears the causes shown are identical.
Not entirely, because the day-to-day condonation is pleaded. Day-to-day condonation has been pleaded in this application. On which day conference was held, and every details are there here.
Are almost identical. Paragraph. Hence, there is no question for this court to take a different view in this application. Hence, there is no scope for this court to take a different view in this application. Paragraph. Accordingly, by today you will file, or tomorrow.
Transfer the leave at the backsheet of the written statement. I will file it today.
ওটা এন্ডোর্স করে দাও পিয়ারটা বাই টুমরো করে দাও in view of the foregoing reasons and discussions, comma, paragraph, the mandatory period of 30 days stands extended till tomorrow. That is
tomorrow is the 13th of
November 13, 2025. And the applicants / defendants shall be at liberty to file its written statement before the concerned department by working hour of tomorrow, that is November 13, 2025. এই ডেটগুলো বোল্ড হবে। Paragraph. The defendant shall pay cost. No, you have time till
54 days only. I have time till 18th of December.
18th of December.
Only 54 days of delay. That too, this set of
18th of December. তাহলে এটাকে একটু কবে অবধি করলে?
tomorrow. She give me time till tomorrow.
ঠিক আছে। Upon subject to payment of paragraph করে করছো তো, the defendants shall pay cost of rupees 50,000.
But they are 10.
You said identical ground.
No, I said almost.
Identical order you are praying.
Almost. Kindly
50,000.
10 defendants.
16 to 18 shall pay cost of rupees 50,000
15,000.
in favor of the State Legal Services Authority, comma, West Bengal, positively within 4 working days from date, comma, failing which the written statement shall be returned to the defendants and no cognizance shall be taken thereupon. Full stop.
Kindly make it, Lordship, kindly make it 7 days.
These defendants,
instead of 4 days, kindly give me time for 7 days.
7 days. 4টা 7 করে দাও। The these defendants shall produce a copy of the money receipt for the payment for the cost paid, for the cost to be paid to the learned advocate on record for the plaintiff. Full stop. The fiat on the written statement shall be endorsed accordingly by the officer of this court. Full stop. paragraph. Accordingly, comma, the instant application being bold, IAGA 4 of 2025 stands allowed.
Grateful.
Grateful.
নেক্সট, এসো এসো, এই একই হবে, শুধু ডেট পাল্টাবো।
দিয়েছিলে এটা আগে দিন।
এটাই বলছি, সিনিয়র দাঁড়ালে কস্ট বাড়বে। Yes, Mr. Ghosh.
My lord, may I hand up the copy of the list of dates, my lord?
List of dates now.
My lord, here there are.
Now.
The application is by 21.
One second.
Yes.
প্রথম থেকে পড়ো, আমি জাস্ট ডেটটুকু চেঞ্জ করে দেবো। কেন কি হয়েছে? আমি ডাকিনি তো।
বলে নিচ্ছি।
না, আমি ডাকিনি। না, আমি ডাকিনি। চেক যেই বাউন্স করবে, লিগ্যাল এড সার্ভিসেস কে বলবেন ওই দিনকে সব শুদ্ধ লক স্টক ব্যারেল জেলে পুরো দেবো, লক স্টক ব্যারেল পুরো দেবো, একদম রিপোর্ট করবেন, ইররেসপেক্টিভ অফ হোয়াট ম্যাটার থাকুক লিস্টে না থাকুক, রিপোর্ট করবেন যে এই দেখুন লিগ্যাল এড সার্ভিসেস লিখে পাঠিয়েছে, চেকের কস্ট, এই কস্টের চেক বাউন্স করেছে।
Ours is by DD, so no problem.
আপনি রিটেন স্টেটমেন্ট অ্যাডমিট করুন, সাবজেক্ট তো এটাই, রিটেন স্টেটমেন্ট ছুঁড়ে ফেলে দেওয়া তো আমার হাতে। যে মুহূর্তে চেক বাউন্স করবে আপনি পাঠাবেন, রিটেন স্টেটমেন্ট তো যা হবে হবে, তার সঙ্গে ওই মক্কেলেরও ব্যবস্থা হবে। বলে গেল, আপনি পার্টিকুলার দিতে বলুন,
করে গেছে কাউ,
আমার তো না, পার্টিকুলার দিতে বলুন। হ্যাঁ, রিজন থাকে, সই মিললো না,
insufficiency of funds not acceptable. GA4, GA5, GA4 এটা হয়ে গেল।
আসুন তুমি প্রথম থেকে পড়তে থাকো তো, আমি ডেট জায়গাটা বলে দিচ্ছি। ডিফেন্ডেন্ট নাম্বারস
21 to 25.
21 to 25. কমা দিয়ে টু ফাইল দ্য রিটেন স্টেটমেন্ট, হ্যাঁ হয়ে গেল, তারপর পড়ো। Master summons has been taken out on
10th November.
November 10, 2025. হ্যাঁ, which is কতদিন?
But now there are 3 sets of defendants here. 21 plaint not served, so completely has to be kept aside. I'm waiving the writ of summons and I'm filing the writ of written state.
The office report says something else. The office report says something else. But if my lord will see the second table in the middle, it says service through the district judge's court on defendant 11821.
কি বুঝতে পারছেন?
My lord,
Date of service
my lord,
10th July 2025.
my lord, the table below that. The table below that, there is
Date
another
of
table.
service 9 September.
Yes, my lord. 9 September. Here, my lord will see under the heading service. My lord will
Served
see
upon Naveen, caretaker of defendant number 1.
for and on behalf of defendant numbers 11821. So, my lord, the office, my lord, this report says that the defendant number 21 has
Still
been
within time, there's no problem.
All right. I'm taking it is served. কি হলো? Which is
22 to 24 served on 20th August 2025.
1 second. No, master summons has been taken on.
All master summons has been taken out on 10th November.
Now, which all? You are moving one application.
One application.
That's
so for
right.
all master summons is taken on 10th November.
Master summons has been taken up on
10th November.
November 10, 2025.
Yes.
Full stop. Tapor. Which is the
for 22 to 24, this would be 84th day.
Wait. Which is 84th day for defendant number 21 to
22 to 24.
Defendant number 22 to 24 and
116th day.
116th day for
defendant number 25.
Defendant number 25.
21 to calculate করে বলে দাও. 21 I will give you lordship.
9 September.
তাহলে এটা এন্ডটাকে কমা করে দাও.
Yes, I'll just calculate it.
And blank day for defendant number 21. ঠিক আছে, পড়ো next. From the date of service of writ of summons. পড়ো. Plaint was presented on
Plaint presented on 19th of
June 19, 2025. তারপর
the same.
August. देखो July 17, 2025. Writ of summons appended was served upon defendant number 25.
That's right, my lord.
And the same was served. And the same was served upon defendant number 22 to 24 on August 22, 2025. Date gulo bold হবে. তারপর পড়ো.
What is the date? 21.
21
9/9/21. 25.
9/9/25. September 9, 2025 upon the defendant number 21. Next. On কবে on
All three different. It would be different.
give me
30 days expired. Your lordship wants that date. 30 day expired.
এখানে লেখো এইভাবে একটা রাইডার করে রেখে দাও, ওই পার্টটা শুধু এইটা লিখবে. For defendant number
22 to 24
the mandated 30 days
expired on
29 20th September.
19/9/2025.
September 19, 2025. And for defendant number
25 it expired on 16th August 2025.
August 16, 2025. Full stop. And 21, what about 21?
The first date that your lordship wanted, which is blank, that is 62. 62nd day.
62nd day.
আগে blank টা ছিল.
62 ND.
Yes.
Day.
And this blank that is filed
32 expired.
30th day.
30th day. And for defendant number 21, it expired on
8/10/2025.
October
Full to my land.
8, 2025. Sir, this is a formatted order you have already have in the judgment. You don't even bother to calculate and bring it.
The difficulty is that
there's no difficulty. Say that you haven't done.
I haven't done it.
Don't say difficulty. We should have got it.
I don't mind, sir.
We have
In the way, half an hour, 45 minutes gone. The next matters cannot be taken up. How does it matter to me?
We have explained the 120, but 30 days should have also been mentioned.
Formatted order, you should have corrected and give it to me. Who disbelieves you? When written statement was affirmed?
10th November.
November 10, 2025, the written statement was affirmed. Defendant, on the behalf of these defendants. When it will expire? On
For different people, different days.
sometime in December.
No, for 25, it will expire on
Likho,
14th
stop,
November
for
2020.
defendant number 25,
It will
the
expire
128th day shall expire on
14th November 2025. That is mentioned in your lordships.
November 14, 2025.
For different numbers 22 to 24, it will expire on 16th December 2025. And for
Defendant number 21,
it will expire on January 7th, 2026.
বাস তারপরে কি বলেছে? বাস ওই ওখান থেকে সব এক হবে। চলো।
The rest will more or less be the same. The rest of the order should be.
One thing, kindly check up, Mr. Ghosh. There I find a mistake of date. Kindly just see the mark in the judgment. It should be 25, I believe.
Para 5.
Yes, my lord, it would be.
25. To be mentioned করে কালকে দেবে লিস্টে। এইটা to be mentioned কাল দাও।
দরকার না for 25. Tomorrow your lordship has given us time till tomorrow to put in the cost and my lord acceptance.
না না, cost 7 days.
For 7 days and my lord
Statement tomorrow.
by tomorrow.
এই এটা এন্ডোর্স করে ছেড়ে দাও পিয়ারটা একই tomorrow.
So দিয়েছো এটা দিয়েছো
ওখানে মারাত্মক ভুল ছিল।
দিয়েছো নিয়ে নাও।
25টা 24 হয়ে গেছে, আমিও খেয়াল করিনি। নেক্সট।
My lord, I appear for the decree holder. My lord, this is my application for execution of a consent decree of 2021. My lord, on the last occasion when this matter was taken up, my lord, the other side, the judgment debtor had sought an adjournment stating that there was settlement, they will attempt a settlement. My lord, on this specific ground, an adjournment was granted and the last order contains a direction that
So basically, today is the first day.
No, my lord, may I just say this? My lord, on the last order, my lord, in para 4, my lord, there's a direction that if settlement does not take place on the returnable date, the affidavit of assets will have to be filed. Nothing has been served on us, and there is no settlement that has happened between the parties, my lord.
Show me your tabular statement.
Yes, my lord.
Lord, only one thing, my lord.
জাজমেন্ট ফর্মে করে জাজমেন্ট হিসেবে আপলোড করবে, ঠিক আছে? যা
My lord,
যে
that is
ফর্মে
at page 1.
বলে দাও, বন্ধুদের বলে দাও, আমার যেগুলো যে2 ফর্মে হবে জাজমেন্ট বলে দেবো, সব জাজমেন্ট হিসেবে আপলোড হবে। Yes,
My lord, that is at page
Show me the,
183, my lord.
Huh?
It is in volume 2.
No, tabular statement.
I'm sorry.
What was the suit for?
My lord, the suit was for monies paid under an ICD. 1 crore was advanced in January 2019 as an intercorporate deposit that was payable.
Have you not furnished any particulars of property?
My lord, no, my lord.
Have you not furnished any bank account?
No, my lord, we could not ascertain any, my lord.
All right.
My lord, may I just say this? This was originally a consent decree, my lord, for a sum of 1 crore with interest along with principal payable within September 2021. And in default, interest was provided.
You have twofold submission.
As on date, of total sum of 68 lakhs is due.
Mr. Ghosh.
First is maintainability, because we got
maintainability. Deposit the entire amount.
I'll just show your lordship. Court does not have jurisdiction.
First deposit, then
and secondly, my lord, this execution application, its current form
is not maintainable, he should withdraw and file afresh.
Why?
Lordship will kindly see, take the affidavit in support of the master summons, in support of the tabular statement.
Why?
Lord, there is no statement pertaining to attachment of any property, which is, Lord, a submission on fact. There's no statement which is made as true to knowledge. Everything is only a submission.
All right. First to disclose your assets and properties,
I
bank
will, my lord.
accounts. No,
But
I'm
as of now,
directing.
my lord, Lordship will kindly
I am
see-
recording.
Yes, my
Everything
lord.
will be
Lordship will kindly
considered.
record.
Ashu.
Kindly record, my lord. And Lordship will kindly see in his cost title.
I will come. Even the quality of paper on which it is typed, I will see. No problem.
And computation.
And computation. I will see. No problem.
Yes.
Ashu. This is an execution application arising out of a consent decree dated
15th March 2021, my lord.
March 15, 2021. Full stop. তার মাথার উপর লেখো. What's your name?
My lord, Robindra Kumar Mitra.
Ravindra Kumar? Ravindranath?
Robindra Kumar Mitra, my lord.
Ravindra Kumar?
Mitra.
Oh.
He's Justice Mitra's cousin.
Ravindra Kumar Mitra, learned advocate, appears for the plaintiff decree holder.
Yes, my lord.
Actually. Paragraph. Mr. You are there for whom?
My lord, for the decree holder only. I'm with him, my lord.
With Mr. Such and Such. What's your name?
Rishabh Datta, my lord.
Rishabh Datta, learned advocate, appearing physically. তারপর Mr. Soumamo Ghosh, learned counsel, appears for the judgment debtor. Paragraph on October 27, at the outset, Mr. Ghosh has taken the point of maintainability of the execution proceeding. Full stop. Paragraph. On October 27, 2025, when the matter was taken up for consideration, on the plea of settlement, a plea of settlement was taken by the judgment debtor. Full stop. Today, the party is informed that no step has been taken for settlement and there is no scope even.
My lord will kindly see para 4 of the last order, my lord.
Full stop. The coordinate bench on the last day has observed and directed that if the judgment debtor fails to pay the amount to the decree holder, comma, the judgment debtor shall file its affidavit of asset by today. Full stop. Paragraph. No affidavit of asset has been filed.
Lord, we have affirmed one.
Give it. Stamped and punched.
Stamp punch for us? Yes, stamp.
So give it.
And my lord, he's also indicated that it's not that there's no chance of settlement. It can be settled, but insofar as
Anytime. Plaintiff, if agrees your settlement, he accepts money, whatever. How does it matter to court? Anytime. 1 crore if settled at 100 rupee, court has nothing to do.
If a reasonable offer is made, my lord, we are. A copy.
What is that?
no, that is the affidavit of service, affidavit of assets, and the affidavit of wakalatnama and the competency. my lord.
My lord, let the copy be served on.
I'll have to. Naturally.
Wait. বলেছি পড়ো না ওটা লিখবে না কি লিখেছি পড়ো না, নো অ্যাফিডেভিট না, লেখো নো অ্যাফিডেভিটটা কেটে দাও, লেখো pursuant to the said direction
হ্যাঁ, সেটা তুমি বলছো whenever you want to settle, you settle.
the judgment debtor files an affidavit of asset today in court, comma, the same is taken on record. Judgment debtor also files wakalatnama and
Competence, affidavit of competence.
department.
I'll file
The judgment debtor, on the prayer of the judgment debtor, leave is granted to file the wakalatnama and the affidavit of competency in the department, before the department concerned by tomorrow. Paragraph. On perusal of the affidavit of asset, it appears that the income of the judgment debtors as shown therein with reference to its alleged annual report are not all report, comma, are not realizable for the present, at the present moment. Are not realizable at the present moment. 7. Except the alleged income from business of rupees 93,000. No immovable, no fixed asset is there. Allegedly. Only one bank account has been shown. Paragraph. A copy of the affidavit of asset shall be served upon the learned advocate on record for the plaintiff, decree holder, by tomorrow. Paragraph. It's a running business or what?
Yes. Nothing.
Running.
It's all gone. My lordship sees the
Name of the judgment letter. Everything gone. Big tea company which they used to run, that's also gone. Now being taken over, I believe, by Eveready. Right? No.
The present management paragraph of the judgment debtor company is directed to be present personally before this court on the next day. To apprise this court on its stand on the said compromise decree.
My lord,
Yes.
My lord, I'm praying for an injunction on the bank account till such time, my lord. My lord, this is a company having an authorized share capital in excess of rupees 8 crores.
Show me
And
the
they-
bank account details.
My lord, I believe there is a I may have missed out, but my
How
lord,
can I
there's a
pass an order in the air?
No, it is there, my lord, in the
there is the affidavit assets, my lord.
One
mentioned.
HDFC account.
It is the only account. And that also overdraft. That's what I've been instructed.
93,000 and odd. There shall be an order of injunction restraining the judgment debtor, respondent, and or its main agents, servants, assigns from operating the bank account mentioned in paragraph 7 of the affidavit of asset maintained with the HDFC Bank, Central Plaza, Kolkata. Until further order.
Lord, Central Plaza is outside jurisdiction. It's outside jurisdiction. In the Sharad Bose Road.
The judgment debtor, the judgment debtor and its servants, agents, assigns are directed that before operating any of its bank account, shall apply before this court for obtaining prior permission. Until further order.
Great, my lord.
Search out, search out.
One thing, my lord, their prayer for attachment, paragraph 22 of their affidavit in support. Perhaps they could not pay for the extra prayer.
My lord, my prayer is in the tabular statement as prayer G, my lord. Prayer of injunction restraining them from disposing of assets.
All in
It's
submission.
prayer G.
The matter
No,
shall
it's prayer
appear
G in the
under
tabular
the
statement,
heading
my lord.
New chamber application on December 9, 2025. Paragraph, the plaintiff shall presidency.
My lord, only one submission, my lord, out here. Since there are no assets, my lord, as far as their creditors are concerned, can there be an attachment?
Give me the particular. No order can be passed in the air.
Also, I must indicate, because Mr. Dutt is here, the computation at in the tabular statement of the amount due. That is also incorrect. I'll indicate the correct. That is but before the
We have checked the computation, my lord. In my reciprocal submission, it is
not in terms of the decree. That's one. And the other point is the court does not.
That on the first date was not taken.
No, may not. It doesn't matter if on the first day it's not taken. Doesn't mean you are going to. I'm not going to allow.
My lord, one humble prayer. Can it be on 10th, my lord, if subject to my lord's convenience?
My lord, 10th.
My lord, 10th, if it is possible, or any other date apart from 9th.
No, 16th.
Great.
December 16th, 2025.
My lord, will you please to fix a time, because
Lordship never for the.
ছাড়ো না
Lordship never fixes a time.
Please, my lord.
Yes.
Sir, in terms of my Lord's order dated October 27, 2025, my lord, I had visited the premises, my lord, and had done the necessary acts, and this is my report, my lord, which carries the original keys.
What was the direction you have carried out?
Yes, I had visited the premises, my lord, and I had taken.
You have?
I had visited that premises as directed in the order dated October 27, and I had taken over the keys from the director of the defendant.
So file a report.
Yes, my lord. I'm carrying the report. This contains the original.
Parties are all here.
Yes. And I'm serving the copies of the reports to both.
Wait. Unless I give leave, how can you?
Very well.
Mr. Shantan Bose, London advocate, senior advocate, appears for
the plaintiff.
Plaintiff. Mr. Siddhartha Banerjee, London counsel, appears for the defendant. Sole.
Plaintiffs, there are two plaintiffs.
What are plaintiffs? Plural. Defendant, singular. London receiver, Mr. Altamas Alim. Files his report of inventory in a sealed cover. Full stop. The same is taken on record.
Containing the keys.
Full stop. Kholo eta. The seal has been opened in court. Full stop. Landed receiver is directed to serve copies of his report to the landed advocate on record for the parties. Do it. Full stop. Copies of the report are served accordingly in court today. Yes, what is the matter about?
My lord, here, my lord, it's basically a money suit.
Bring it on. কি হয়েছে? চাবি চাবি আমার কাছে কেন থাকবে? চাবি তো ওর কাছেই থাকবে, কোর্টের কাছে চাবি থাকে না।
The earlier keys I had submitted before the court, that is why. My lord, earlier also I had visited the premises and I had taken over and I had put a padlock. That keys I had submitted before this court, my lord.
Certainly not.
Very well, then
Keep it with you until you are discharged.
Very
Then you have to submit it before the after discharge. You have to submit before the registrar.
Then may I take back the keys?
Yes, I'm recording. Where is the last key? What are
Last key is also, my lord, in the records of this court, my lord.
খোলা হয়েছে?
Ah,
সব
yes.
বোনাস করেছে, তারপর কেউ ডুপ্লিকেট করে ঢুকে ভাড়া দিয়ে দেবে। চাবি 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 লাস্ট ডেজ রিপোর্ট সার্কুলেটেড।
Yes, 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 yes.
চাবি থাকলে চাবি বের করে ফেরত দিয়ে দাও, দিয়ে দাও। বাট কোর্টে আবার চাবি রাখে নেই।
It was part of the report, my lord, that is why.
Have you seen Hirok Raja's দেশে?
No, my lord, I
আরে ধ্যাৎ, দিয়ে দাও।
have not seen, my lord. Wait,
এগুলোতে কেউ কিছু জানে না, দ্যাট ইজ দি ডিফিকাল্ট। Landed receiver has informed this court that how many sets of keys?
4. The earlier
4
ones,
sets
4.
of keys. Total.
6.
The 6 sets of keys in respect of the subject premises.
Yes.
You have taken possession,
Yes.
of which landed receiver has taken possession
Of the premises, madam. Of one premises, madam.
Subject premises of which the landed receiver has taken possession, comma, pursuant to the direction of the coordinate bench, comma, are lying in his custody. Full stop. He shall not part with such keys to anybody without leave of this court.
Great.
Just keep it.
Yes, yes.
Never ever do this.
I was not aware. I shall do.
এগুলো যেমন কে দেখবে? এগুলো কোর্ট থেকে কে দেখবে? তুমি রেসপন্সিবল।
You have paid the remuneration.
No, remuneration was directed in the last order.
Whatever
Also-
remuneration was directed, madam, that has been paid.
Yes, whatever was directed.
What was the remuneration paid?
40,000 and thereafter 40 year.
How many times you have visited?
4 times.
And what was the amount paid?
Lord, if I'm not wrong, Lord, once it was paid, my lord, a sum of rupees 40,000. 40,000, my lord. It's mentioned in the orders, my lordship.
On query being raised by this court, landed receiver has informed this court that he has visited the premises 4 times.
Madam, 40 and 30. 30 the payment
Paid.
Yes, yes, yes.
70 paid.
70
Yes.
paid.
You have visited 4 times.
4 times. On different.
বুদ্ধি বেরিয়ে গেছে, কিছু দিতে হবে। কি বললাম?
By this court, the receiver has informed that
He informed that he has visited the premises 4 times and the total remuneration as on date has been paid to the extent of a sum of rupees 70,000. কে পে করেছে? Who has paid it?
The plaintiffs.
Plaintiff.
Paid by the plaintiff, comma, paid by the plaintiff. A further sum of rupees 30,000 shall be paid to the learned receiver by way of remuneration for the time being by the plaintiff. Full stop. The remuneration already paid and shall be paid by the plaintiff shall be taken into consideration at the time of final hearing of the suit and its fate, FAT. Yes.
My lord, this is a money suit. In which, my lord?
এই আগের রিপোর্টটা আর এই রিপোর্টটা একসঙ্গে রাখুন। Yes.
in which, my lord, relying upon certain documents, relying upon certain documents, my lord, an order was passed.
Today I'm hearing which application?
My lord, an application under Order 38, Rule 7. That is for attachment.
Attachment.
Now, my lord, what happened was, on admission, it was found that there were
What is
admitted.
the claim in the suit, Mr. Bose?
My lord, it's money suit, my lord.
No, okay. What is the claim extent?
I'll tell you, Lordship, my lord. It is to the amount of 3 crores and odd.
Acha.
3 crores and odd. Then, my
have they filed the written statement?
No, it has a little checkered history.
120th day.
Nothing. They took out an application. First, my lord, they had appeared.
It's a out and out commercial suit or converted commercial suit?
No, it was an out and out a commercial suit.
Acha. So from the date of written statement,
120.
30 days. From the date of service of written statement, 30 days elapsed. How many days have elapsed?
No, 120. They had taken out an application also for extension, which they abandoned. They did not proceed with it. No one appeared.
No, but what is the fate of it?
That was dismissed.
Acha.
Now, my lord, it's an undefended one. Now what happens is, thereafter we take out an app. No one was appearing after a certain point of time. Upon perusing certain documents, it was found that there was an admitted claim. They were directed to file securities, furnish securities.
What was the cause of action in the suit for money claim?
My lord, there were certain transactions with regard to advertisements.
Services rendered.
Services rendered.
All right.
They did not pay. Now, my lord, they have given a confirmation of accounts also, which confirms that this was the amount which was due and payable. On the basis of
what is the quantum?
My lord, it was 3 crores and something.
Confirmation?
Yes. 3 crores 12 lakhs.
That's the confirmation?
Yes.
And the total claim?
3 crores 60 something.
Achha. Then?
Now, my lord, on the basis of documents, directions were given to furnish securities. They did not furnish securities. In fact, at the time when directions were given to furnish securities.
Any specific direction with regard to the nature of security to be
Yes,
furnished?
I'll just bring your lordship to that order.
Like a story.
Yes.
Tell me.
They were directed to furnish securities with the registrar by way of check or demand draft, whatever it is. They did not file any securities. They did not file any securities.
By check or
not check, I'll tell you, lordship, but they were directed to furnish securities to the extent of this much.
In cash?
Not in cash. Not in cash. Further directed to furnish security to the extent of certain such, my lord, fixed deposit in any nationalized bank of auto renewal till the disposal of the suit. Thereafter, my lord, they had contested at that point of time. They did not.
Appeal carried out?
No. They did not appear after that. Thereafter, my lord, they did not appear. On my application, since they did not furnish securities, we gave details of accounts, details of assets. In the initial stage, there were 4 assets we had furnished. After that, we found that there were 2 assets which were in their personal names and not in the name of the defendant, which is a company. They are the sole 2 directors, the husband and the wife.
Are they parties to the suit?
No. The company is the party. Thereafter, no one appeared. The properties were attached. Since it was found that it was in the name of the personal name of the individual properties, we excluded the 3 and we went.
What 2, 3?
Well, there were 4 properties.
So personal properties were excluded?
Excluded, and we filed a supplementary affidavit on the basis of which an attachment direction was passed on only 1 property.
That's the corporate property?
Yes. That's an admitted position now. We disclosed deeds of conveyances by which it was found that it was in the name of the company. They did not appear till now. When the learned receiver went to take to make attachment, and
what is the nature of that property?
It's a registered office.
No, nature.
But it's an office.
Office premises?
In a building.
Office?
In a building.
Acha.
Commercial.
It's owned by the company.
Yes.
Injunction made.
Yes. Thereafter, when the receiver went, they woke up from slumber. First time when the receiver went, for the 4 properties, they found one of the properties, it was the personal residence. One of the properties, very peculiarly, one of the properties was attached by SBI and it was already sold to another third party. The third property, very peculiarly, did not exist, though a deed of conveyance existed. A registered deed of conveyance.
But the property does not exist.
Does not exist.
They might have merged.
Nothing. Nothing.
Properties merged into a single one.
No.
Subsequently.
We have given
then-
records where it
then-
shows
then-
that's
then-
a single property. Be that it may be, they are individual properties, nothing on that. The corporate property, they wake up from slumber and they file a supplementary affidavit, they come before the court. And they seek to file a supplementary affidavit saying that there are surfacey proceedings against this property and it was attached. They file a supplementary affidavit. There they give, my lord, the 13.2.13.4 notice where the name of that property is there.
The attached one, the injuncted
Yes, the
one.
injuncted one or the attached
Corporate one.
or the
yes.
attached one. Now, we made a search. In the search, there is nothing. They come before the court and say, then sale notice given of 2 other properties which were there in the 13.2.13.4 notice. Those 2 sold perhaps because sale auction notice has been given. The third has been omitted.
Don't you remember that scene of Sonar Kella? Vanish?
Yes, vanish. The one property has vanished. One property has vanished. এবারও ফিরে আসবে। Then what happens is,
can you run after one Mercedes?
No, they don't have a Mercedes. They are very, very.
Can you run after one Mercedes?
No, I can't. I can't. Impossible.
It will not
A
suffer.
Ferrari would be necessary to run after that. My lord, thereafter, my lord, Sarsai report does not have that recording of that property. They say we'll furnish all the details of the surfacey proceedings, their appeal and everything. They disclose the appeal. They disclose what was there, the appeal, the order. The appeal has been rejected. The section 970.
Neither here, not there.
Are not there. Now what happens is, they give a list of orders, which are orders are not there.
Neither here, not there. How does it matter to you?
But now the thing is, my lord, since it's not there in the search, the main doubt is whether the property has been released or not by the Kotak Mahindra Bank. Now that is one direction they had, my lord, on the first day, my lord. He has been very fair. He had said, I'll disclose everything, including what was not. I would be praying for only one direction from your lordship, though the bank is not a party, to give, to come before the, or to make a statement that whether this property is still attached or not.
How can I direct on the bank who is not a party? And this is not even in execution.
Not in execution, but in that event, let the attachment continue.
Which attachment?
But this, they cannot rely
order
on
of
the
injunction,
yes,
receiver.
Yes,
of course.
But
that
they
will be-
cannot rely on the surfacey proceedings without disclosing
That I
anything.
did hear then.
Yes, without disclosing anything and saying that because of the surfacey proceedings, my injunction and attachment cannot remain.
Yes, Mr. Manager.
No, we are a little late. We'll have to, under the same order, we are also directed. We'll have to put the affidavit my learned senior friend was talking. 2 minutes furnish all the.
One second. Well, in that event, since your lordship is hearing, or if your lordship is prima facie hearing it, I won't place it on, and I won't go into the documents now.
No, I will, if
Very good.
necessary.
Then I'll just.
I will, if necessary. Let me hear it. What is this?
We are directed to file an affidavit disclosing what has happened to the property under the Surfacey Act.
What has happened to it?
13.2 notice issued, 13.4 symbolic position taken, challenging that a securitization section 17 application filed, which is pending before the learned tribunal. That is what we have disclosed.
How will it help you?
Should I open my argument today, my lord? I'll just indicate. My lord, Section 60, my lord, of the Code of Civil Procedure indicates, my lord, which properties, what kind of properties, my lord, can be attached, my lord, in a civil court. It says, my lord, only those properties which are at
How will you secure the money? Tell me.
that, my lord, I need to take instruction. So far as this property
Secure
is
the
concerned,
money.
there is
That's
a
the
tug of- that, my lord,
commercial code. It is a commercial code.
my lord, we lost, my lord, the bus. We missed the bus. We could not, my lord, file the rating statement. I am also, my lord, a late entrant.
You will have a right of cross examination.
That's true.
Undefended suit.
That's true. And possibly, my lord, I have a hope that, my lord, in course of cross-examination, my lord, we will be able, my lord, to build up a case, my lord, to convince my lord that, my lord, this money which they are claiming is, they are not entitled.
Mr. Counsel, those stages are over.
That's true.
You just tell the court how will you secure.
My lord, let me, my lord, take instruction and come back then. So far as this property is concerned, I believe, my lord, there is a tug of war today between, my lord, the bank and my learned senior.
That will be seen
And,
later
my
on.
lord, subject to, my lord, my limitation of understanding, since, my lord, there is a 13.2, my lord is ever of, my lord, 13.13 of, my lord, the 2002 Act. Once, my lord, 13.2 notice is issued.
And by operation of law and injunction.
Correct. So, my lord, section 60 of the code, my lord, comes to play, and the property is no more at my disposal. If that is not, my lord, at my disposal, that is not liable.
How will you secure, sir?
My lord,
State.
let me take instruction and come back. My lord, I have not been able to see to
So
it
let
that
the injunction remain. It's not a limited order of injunction.
No.
The receiver has taken possession. Receiver has taken possession.
Let it be under symbolic possession. Let it be under symbolic, physical possession, whatever it is.
So, my lord, today's symbolic possession is with the bank, physical possession is with the receiver. That is, my lord, the situation today.
আসুন আগের পার্টটা দিয়ে দিয়েছে এবার লিখুন since the keys are with the receiver of the subject premises, comma, the property is under physical possession of the receiver, landed receiver. The landed receiver, has he installed the board? Where is he?
He has, my lord,
He has put on 2 notices, affixed 2 notices.
Where is he?
Well, it's the photographs are there in
Sir,
the
my lord,
receiver's.
annexed to the report. Photographs are annexed to the report. বুঝতে পারিনি।
Mr. Bose, the time has come.
I know, man. I know.
All Mr. Banerjee, Mr. Bose, you must teach the juniors.
I know, my lord. It's embarrassing for us, in fact. It's becoming
The time
embarrassing.
has come. Time has come.
My lord, the only difficulty is that, my lord,
One must realize that he is an officer of the court.
Yes.
When he has been appointed as a receiver, he is nothing but the court. Since the court cannot go personally, it appoints receiver. And the matter is being taken so casually. Yesterday, this gentleman, landed receiver, has mentioned the matter
I know.
that I cannot go today. Please defer.
I know.
Despite direction.
Yes.
I said, then you leave the job.
বলেছিল আমি যাব না আজকে স্যাটারডে
So high-handed. Basically, they do not know.
বুঝতেই পারেন।
Well, they are not aware. They are not aware. They are ignorant, I would say. They are ignorant.
He's from whose chamber?
But I'm quite a good name, my lord. We know, everyone knows that, knows that person. He will not be that, my lord. Groomed in
Sir,
that way.
this is the question of grooming.
My lord, from his chamber, I don't think, my lord, this.
I do not know, but this is the question of grooming.
My lord, we all respect him and love him, in fact.
Yes. Huh? The learned receiver is now directed to put a proper board on a conspicuous portion of the subject premises, which is noticeably visible, which shall be noticeably visible to the public at large, indicating that the property is under the physical possession of the learned receiver appointed by this court.
But the padlock may also be
বলে দেবেন,
sealed.
বলে দেবেন।
And
Huh?
my lord, the padlock may also be sealed.
Yes,
and my lord, signature may be put on my lord the same.
The padlocks put on the padlock/locks put on the main entrance of the subject premises shall be properly sealed.
Kindly say entrance, my lord. Main entrance may be something else. My lord, kindly say entrance to the subject premises. It's a portion of
Entrance
a property.
of the subject premises
Grateful, grateful.
shall be properly sealed by putting the signature of the learned receiver.
Perfect.
This exercise shall positively be done by the learned receiver within 2 days
In presence of
from date.
in presence of my lord both the parties.
In presence of the
But both the parties.
Both the parties.
both parties. And a minute shall also be drawn accordingly and shall be furnished along with the report before this court by the learned receiver on the next day. Interim order is still when?
Well, it's there. It's confirmed.
Since the interim order already passed in the matter, stands confirmed, comma, as informed by the parties.
Interim order of injunction, not the attachment. Interim order of injunction.
Interim order of injunction
Yes, yes.
passed on.
We will supply the date. We will supply the date.
Give it to me. কি বললাম পড়ুন? Interim order of injunction passed on.
বলে দেবো কোর্ট অফিসার দেখে নি আমারও বৃত্ত পড়ে
কেন? হ্যাঁ?
This is the affidavit that we have filed today, pursuant to my lord, the honorable coordinate bench's decision direction.
Interim order, give me the date.
20th of September 2024.
September 20, 2024. কি বললাম পড়ো? Has already been confirmed. Comma. The prayer for further interim order shall be considered subsequently. The prayers for further, Mr. Bose, the prayers for further interim order made by the plaintiff shall be considered subsequently.
But attachment is already there.
Seal
Injunction has already been confirmed. Full stop.
doubly secured, my lord. There is a receiver, there is an order of injunction.
Yes, full stop. On the prayer of Mr. Siddhartha Banerjee, learned counsel appearing for the petitioner, leave is granted
Defendant.
to the defendant to file
No, my lord,
supplementary affidavit. Full stop. Supplementary affidavit filed in court today is taken on record. Paragraph.
চুপ করবে।
Copy has been served.
Yes, yes.
Copy has already been served upon the plaintiff.
If senior friend wants to, my lord, reply
10 tips. Huh?
Reply to what?
My lord, if my learned senior friend wants to, my lord, respond to
That's
this.
right, that's right. Plaintiff's paragraph shall be at liberty to file objection to the said supplementary affidavit by way of an affidavit.
We also use a reply, my lord. If required, my lord, we will use a short reply.
Come, then we'll see.
Wait.
Wait. In the meantime, the matter shall appear under the heading
Adjourn.
adjourn motion on
সুশীল মাঝখানে যাবো কিভাবে?
December 17, 2025.
Great. Great.
Make the junior understand that learned deceiver.
I will speak to it.
This conduct is not appreciated.
Not intentional, my lord. He could not understand.
He doesn't know. I appreciate. But when will he know?
We'll try to do whatever we can.
My lord, I'll talk to him. Both of us will talk.
Grateful.
Yes, next.
Item number 17 and item number 18.
My lord, IPO for the petitioner, my lord. My lord, IPO for the petitioner, my lord. 17 and 18, my lord, are two applications, my lord. GA1, my lord, is an injunction application, my lord. Both application GA2 is an application for attachment before judgment, my lord. Both are in respect of a suit for money lent in advance, my lord. This is fairly, my lord, similar to the to yesterday's suit, my lord, where Mr. Sudhashatto Banerjee was making submissions, my lord. Money is lent in advance, my lord, in the ordinary commercial course, my lord. Money is not paid, my lord. We filed, my lord, my lord, we are an NBFC, my lord. The asterisks, my lord, on the same line, my lord, roughly what Mr. Sudhashatto Banerjee was submitting yesterday. The only difference here is that, my lord, there's no demurrer application in this proceeding, my lord. So my task is a bit easier. My lord, GA1, my lord, is my injunction application, my lord. We had gotten an interim injunction, my lord. I'm led by Mr. Gupta, my lord. My lord, that order was vacated, my lord, for want of non-compliance of Order 39, Rule 3. My lord, I'll place that, my lord, order. The brief, my lord, was not paginated, so it was vacated, my lord. My lord, GA2 is my application for attachment before judgment, my lord. That is also possible.
Yes, my lord.
May I place that?
Then what happened?
My lord, we had filed GA2, my lord, application for attachment before judgment, my lord. In one of the orders, my lord, while this application was being taken up,
Have
my lord,
satisfied the test of Justice D.N. Sinha's judgment. Here, 51 Calcutta.
my lord, my lord, I'm not personally aware. I can't recall the judgment, my lord. If it's the Trinity test, my lord, we have.
Yes, the 10 paragraphs. Air 51 Calcutta. Justice D.N. Sinha.
Yes.
Which was affirmed by Supreme Court in 2000, Ramanna. Ramantek.
Yes.
Affirmed by Supreme Court in Ramantek.
George Saab second.
Which order you are vacated?
My lord, that's the order of 2nd of March 2021.
2021?
Yes, my lord. This is this
Change brief which has come.
change brief, my lord. There was a change in the advocate.
Possibly because of that vacating order, we got a change. I don't know.
Yes.
Yes. My lord has the order of 2nd of March 2021.
I've seen. Then what happened?
My lord, then we prefer a second application.
But who is on the other side?
My lord, Mr. Devnath Ghosh is appearing. I will take the notes, my lord.
So better come tomorrow. Let it remain in the list.
Tomorrow and day after, I'm not there. Will be any day next week. I'm not in town.
Then it will not be taken up soon. Then it will not be. I will not be able to take up soon, because the others must get the chance.
Whenever you know, but because I'll not be there tomorrow and day after.
দেখুন, I can pass it over, it will appear, it will remain in the list. But tomorrow it will be called on. If the matter reaches.
It will reach, it's appearing fairly at the top, it will reach.
It will reach, my lord. It's appearing fairly at the top because all the other previous matters have been over, my lord. So no point troubling your lordship coming tomorrow again and praying for that time.
On the prayer of Mr. Chayan Gupta, learned counsel appearing for the plaintiff, the matter shall appear under the heading adjourn motion. On December 17, 2025.
I'm really sorry, my lord. This matter fixed prior to my change of determination. It's already fixed somewhere. So I'll be.
Mr.
Gomes. Mr. Gomes.
Full name.
Patrick Gomes.
Patrick Gomes, learned advocate, appears for the defendant. Sure.
Item number 19.
এটা কিন্তু ওই পরপর দুটো ম্যাটারে হলো, তাই তো? 17-18.
This is, I'm for the defendant, my lord. I'm for the defendant, my lord. This is my application, my lord, for transferring the suit from commercial division to non-commercial division, my lord.
And I am for the plaintiff, my lord. My lord, I am led by Mr. Bag, my lord. Let the defendant number one star, I'll take note.
What is the plea?
My lord,
Take the microphone.
My lord, the suit, my lord. If I briefly indicate the fact, my lord, the suit, my lord.
Suit is for?
Suit for money. Suit for money, simplicity.
Goods sold and delivered.
No, my lord. Suit for, my lord, if I briefly.
Rent and advanced.
No, my lord.
Then?
My lord, the defendant number one, my lord, is an association of transporters. Plaintiff is one of the transporter. My lord, there was an agreement between the plaintiff and Air India regarding, my lord, sale of tickets.
Sale of?
Tickets, my lord. It was due to shortfall to meet up the target, my lord. The agreement between Air India and, my lord, plaintiff was cancelled and terminated. My lord, I do not have any jural relationship with the plaintiff. I am not even a party to the, my lord, the agreement between plaintiff and the Air India.
So why it will not be a commercial suit?
It will not be a commercial suit, my lord, because, my lord, it does not strictly, my lord, fall within the
commercial dispute.
Yes, my lord.
Why it's not a merchandise dispute?
No, my lord. That, my lord, I have to show because there has to be a jural relationship between the parties. The agreement.
So suit is not commercial as against you, or suit is not maintainable as against you?
The suit is not commercial because this suit has been filed against me only. Air India has not been made a party. My lord. My lord, I am led by Mr.
You are led by?
Anirban Rai and Siddhartha Banerjee, my lord.
Your senior was here just now, 2 matters back, Siddhartha Banerjee.
Yes, my lord. Somehow.
All right, come tomorrow. Let it remain in the list. Chalo, dike do bahadur. কালকে মনে করিয়ে দেন।
Yes, tomorrow.